My lord, I make an item 11, madam. Kindly secretary must after vacation, madam.
On the prayer of Mr. SL, Unit Council appearing for the applicant stroke appellant, this matter stands adjourned for 2 weeks. Please take- R. Ali.
Back to mention listing of an IA minor. IA is with regard to compliance of the Honorable High Court's order that was passed on 2nd of December, my lord. The order was passed granting bail to the petitioner appellant on the ground that his wife was pregnant and he was about to deliver the baby. My lord. So he has complied with the order, my lord. The baby was delivered and he was with the wife in some circumstances, and accordingly after the delivery he turned up before the jail authorities, my lord. And now, my lord, the condition of the wife is further deteriorating, my lord. So may be granted bail along with the criminal, it may be listed along the criminal appeal.
When do you want it? Monday.
Monday. Blush.
May I please, Your Lordship, I'm back to mention item number 12 of the daily list, Your Lordship.
Yes.
My senior Mr. B. Prasad is in dispute today. Your Lordship, may
He
please
is in dispute.
dispose.
He's not keeping her lordship.
It's not keeping.
What you want?
Your Lordship may adjourn the matter for the day and list the matter after the vacation.
If your lordship will, it is to fix a date, lordship. From 20 to 24th, I will be out of station. Any other day, lordship.
So after that, choose a date.
Lordship, can it be on 25th?
No, 30th, 31st. We'll do it on 31st.
Lordship, yes.
31st. A prayer for adjournment of the hearing of this appeal has been made on behalf of this appellant on the ground that the arguing counsel, Mr. B. Prasad, is unwell and therefore, has not been able to come to court today. Full stop. Mr. R.K. Dev Chaudhary, learned DSGI, appearing for the respondent, has not opposed the prayer, but has made a request to post this matter again on 31/1/2022. In view of the above and on the request of learned counsel for both the sides, this hearing of this matter stands adjourned till 31/1/2023. Register to list the case accordingly.
Obliged, lordship.
Daily list for admission item 1.
May it please, Lord.
Yes.
My appeal against conviction under section 302, my lord, convicting the appellant for life, my lord.
Will admit it.
Stated appeal, my lord.
All right, heard Mr. P.J. Saikal, learned counsel appearing for the appellant. This appeal is presented against the judgment dated 26/9/2022, passed by the learned session judge,
Please.
Biswanath, in connection with sessions case number 285 of 2015, convicting the sole appellant under section 302 of the IPC and sentencing him to undergo rigorous imprisonment for life and also to pay a fine of rupees 5,000 with default stipulation. Stop. We have perused the impugned judgment. Full stop. Also heard submission made by learned counsel for the appellant. Full stop. Admit the appeal. Call for the LCR. Issue notice. Returnable in 6 weeks. Since Mr. J. Das, learned counsel assisting Ms. B. Bhuya, learned senior counsel in ethics aspect, has appeared and accepted notice on behalf of the state stroke respondent number 1. No formal notice is required to be sent to the said respondent. Who is the informant here? Family member.
Yeah, my lord.
We are informed that the respondent number 2 stroke informant is a member of the victim's family.
Right.
As such, notice be sent to the respondent by the inspector. AD.
All right, lord.
Item 2.
Made statutory appeal against conviction lawsuit. The appellants are convicted under section 302 for life. The adjusted appeal must be admitted on record.
All right. Heard Mr. A. Amin, learned counsel for the appellant. Also heard Ms. B. Bhuya, learned senior counsel bracket APP Assam, assisted by Mr. J. Das, appearing for the state. His appeal is presented against the judgment of conviction dated 5/11/2022, passed by the learned additional sessions judge, Jorhat, in connection with sessions case number 241/2006, convicting the appellants under section 302/34 of the IPC and sentencing each of them to undergo rigorous imprisonment for life and also to pay fine of rupees 5,000 with default stipulation. Mr. We have Perus, etc. You give it, and Mr. Das has accepted notice. Victims.
Yes, son.
informant. We are informed that the informant respondent number 2 is the son of the victim. As such, notice is sent to the said respondent by registered post to the AD.
IA is there. Actually. That's not a council.
Heard Mr. A. Ahmed, learned counsel for the applicant. Also heard Ms. B. Bhuya, learned APP Assam, assisted by Mr. J. Das. This IA has been filed under section 389(1) close of the CRPC with a prayer for suspension of sentence and also to release the applicants on bail. Ms. Bhuya prays for and is granted 2 weeks time to file objection. Let the matter be listed again after the objection on behalf of the state is brought on record.
Supplementary list for admission, item 30.
What to do, Mr. Das?
Lordship, may I make one prayer, Lordship, prior to approaching this honorable court, we have approached the restaurant number 4. We have annexed the written communication at page 27. Can that communication be treated as an FIR, Lordship, against the restaurant number 5 and 6?
No, it cannot be. Which complaint?
Lordship, page number 27. It was submitted before the Deputy Commissioner of Police Center.
FIR has to be lodged before the officer in charge. That
That's
is
it.
the law.
That's just I'm making.
Why don't you, why are you not open to accepting the law?
Lordship. Lordship, only anxiety is that Lordship, since the day this petition has been filed, the petitioners felt protected. And now, Lordship, after, if your Lordship is pleased to close the matter, there might be some anxiety on the part of the petitioners, Lordship, that.
What
there might-
anxiety? If you lodge an FIR, we'll say that it should be processed in accordance with law.
Lordship. And simultaneously, Lordship, the other proceedings against the restaurant number 5, maybe before the Police Accountability Commission, that may be.
Nothing. It can't be done like this.
Lordship, we may be given liberty,
You
Lordship.
want a multi-facility shopping mall. Huh?
No, Lordship,
Go to one mall, buy garments, food,
No.
grocery, everything.
I'm making just a making.
You are turning report into that. You are appearing for whom?
And for the respondent number 5, my lord.
What do you have to say?
My lord, the petitioner had approached this court saying that he was not even given the reasons why he was being arrested. And therefore, we had misused the law to harass him. My lord, we have brought on record to show that even before filing of the writ petition, he had twice approached for anticipatory bail simultaneously in the High Court and in the Sessions Court. He filed it simultaneously. Had one of them, in one of the courts, he got a bail order. On the other, without divulging that he already had an anticipatory bail order, he withdrew the bail petition. He has not been acting in with bona fide throughout the entire session. And also, my lord, we have got on record, the government has also got on record the entire case, the entire materials to show that on every occasion, his signatures were taken when he was informed to visit the police station to give his statement. When he did not come, he was asked to report to the police station. He was asked to leave after he had given his statement. He refused to leave.
Hmm.
So
No,
those
but what do
all,
you say about his basic allegation that he was compelled to sign an agreement in the police station?
my lord, that agreement was signed by the parties outside the police station
Hmm.
and a copy was given to us. That is where it stood. We
You are
have not,
appearing for whom you said?
respondent number 5, the IO of the case, my lord. We never got him because the day.
No, but
he
why
had-
it was given to you? What have you got to do with an agreement?
Well, we have got nothing to do. There was an FIR lodged.
Hmm.
There was a complaint made. The matter was processed up. He was just asked to come in and bring us, give a statement.
Hmm.
Where if it was a civil matter, we could have referred it to the civil court. He gave his statement. He stayed in the
So
night.
why was he arrested?
He was not arrested. He was brought to the police station to give a statement.
Hmm.
And he was allowed to leave in the evening.
Hmm.
He said we had to drop him back to his home because we had got him to the police station. We called him to the police station. Now it was our duty to drop him back in our official vehicle. That was refused. We said, you get a taxi, you do whatever you want. But it is not our responsibility to drop back people who come to the police station to give their statements. That is on record, Lordship could find. The entire issue was cropped up when he said that he did not have even the police case number or the FIR number to move the honorable court. That is a specific statement in the writ petition. And Lordship would find in my affidavit in opposition filed by the respondent number 5, Lordship would just have page 13. Page 12, my lord. This was the first anticipatory bail which he moves prior to the moving of the writ petition on 3/12/2021. Six 12/2021, another petition is moved in the before the session judge, giving every detail of the case, where he obtained anticipatory bail. And he approaches this court saying that I do not have details of the case. That is how the police is arresting me. They are simply picking me up.
Who is appearing for the respondent numbers 3 and 4? Huh?
The government,
Government is not there.
Mr. D.K. Sharma was appearing in the matter. They have in fact filed their affidavit also. We brought on record the different documents.
Affidavit dated.
The affidavit is
2 to 22, Lordship.
yes.
8 to 22.
It's a large affidavit. Yes. Color.
All right, you take appropriate remedy as may be permissible under the CRPC, that's all.
The protection of
No
the
protection,
petitioners
nothing.
maybe.
No,
it's
there is no
possible.
ground for any protection. Sorry, I heard Mr. D. Das, learned counsel for the petitioner. We have also heard Mr. R. Majumdar, learned counsel appearing for the respondent number 5 and
Yes, that's my lord, so respondent number 6.
Mr. What do you have to say?
My lord, my immediate submission in this regard is that, my lord, since this matter. My lord, since this matter involves complicated question of facts, my lord, which cannot be adjudicated in a writ proceeding, my lord.
We are
so-
not competent to adjudicate it.
My lord.
High Court cannot do it.
No, my lord, since my lord, so my submission in this regard is that, my lord, let them approach a proper forum, my lord. We will contest that, my lord. So at this stage, my lord, this petition may not be allowed.
Mr. S. Das, learned counsel for the respondent number 6. None has appeared for the remaining respondents. Full stop. The petitioner has approached this court by filing the instant writ petition, alleging arbitrary and high-handed action on the part of the respondent number 5, who is an inspector. Inspector, is it?
He's a sub-inspector.
Who is- who is police officer in the rank of sub-inspector and is posted at the Fancy Bazaar Police Outpost coming under Pan Bazaar Police Station. First, according to the petitioner, the respondent number 5 had not only illegally summoned and confined the petitioner in the police lockup, but had also threatened him, but had also compelled him to execute an agreement with the respondent number 6 for payment of substantial amount of money. Full stop. The above allegation has, however, been refuted by the respondent number 3, that is the Commissioner of Police, is it? Respondent number 3, who has filed the affidavit?
1, 2, 3, 4 jointly also.
By the respondent numbers 1, 2, 3, 4, as well as in a separate affidavit filed by the respondent number 5. Full stop. According to the respondents, the averments made in the writ petition are far from true, and they had, and whatever action was taken in the matter was in connection with investigation conducted in relation to Pan Bazaar PS case number 108/2012, registered on the basis of an FIR lodged by the
Respondent number
number
6.
6. Full stop. Mr. Majumdar has strenuously argued that the petitioner was neither kept confined in a lockup, nor was he nor was there any high-handed action on the part of his client. Rather, full stop, rather, it is the petitioner who has distorted the facts only to get a relief from this court. Similar as the stand of Mr. Das, who submits that there are several disputed questions of facts involved in this writ petition, which cannot be adjudicated in exercise of jurisdiction under Article 226. Full stop. Mr. Das, learned counsel for the petitioner, on the other hand, has argued that his client is apprehending further high-handed action from the police, and therefore an order of protection be passed by this court. Full stop. After hearing the submissions of learned counsel for the parties and on going through the materials available on record, we find that the issues raised in this writ petition fall in two different compartments. First up, the first is pertaining to alleged claim of the respondent number 6 for recovery of money from the petitioner. Full stop. It appears that the respondent number 6 had lodged an ejahar based on which Panbajar PS case number 108/2012 has been registered. Full stop. If the police is conducting investigation in connection with this said case, we do not find any ground to interfere in the matter in exercise of powers conferred under Article 6 of the Constitution of India. Full stop. Insofar as the allegation of arbitrary, high-handed and illegal action on the part of the respondent numbers 5 and 6 is concerned, this is also a matter which cannot be adjudicated in a writ petition. Full stop. If at all the petitioner has any grievance in the matter, it would always be open for him to take proper recourse to law within the confines of the Code of Criminal Procedure. Full stop. Therefore, by granting liberty to the petitioner to take recourse to law for redressal of his grievance in the matter, we close this writ petition by providing that if the petitioner continues to feel aggrieved in the matter, it would be open for him to approach this. It would be open for them, petitioners, it will be open for them to approach this court by filing a fresh writ petition if a proper case is made out on that behalf. Writ petition stands disposed of.
May I just say, madam? The Lordship is noted that the respondent number 5 is a sub-inspector. Now he's promoted, could it be was at the relevant time?
Achha. Now, what is he now?
He's an inspector with the Directorate of Vigilance, madam. At
Who was
present.
then posted as
Was
sub
the
inspector?
Lordship. He's no longer the IO also. Obligation.
Or order item 3.
Lordship, this is an appeal preferred by the state of Assam against the order of acquittal, your lordship. The delay in preferring the appeal, they're filing objection, they say.
I pay for further 2 weeks time for filing objection in this matter.
Lordship.
Ms. B. We are learned application appearing for the state stroke applicant. Mr.
AK Gupta.
Learned counsel appearing for the
Respondent.
sole respondent.
Sole respondent.
Sole respondent. Prays for 2 weeks time to file objection. Prayer allowed. Let this matter be listed after 3 weeks or as soon as the objection is brought on record by the sole respondent, whichever is earlier.
Obligation.
Item 4.
Lord, kindly pass out the matter for timing, my lord.
What is this matter?
Lordship may be taken up on some other day, probably.
No,
Miss- No, Julie by Dinkoria, so she's not present, or I don't have. the
Okay, let him
records.
come. Why you want to pass over? Why?
No, I have no problem, my lord. He's in leg, my lord. My senior, Mr. T.H. Hazarika.
Who? Your senior?
Mr. T.H. Hazarika.
Let him come, then we'll
Okay.
pass over.
Now, if.
Kindly.
Ahibadu? Ahibadu?
Item 5 and 6.
Lordship, in this case, a report was called for my lord,
Ossification test report.
regarding the ossification
It
test.
has come.
Yes, probably it's in their favor. I've just gone through it, the office note, your lordship, it's there. We have not been provided with the report.
Where is the report? Is it on
Lordship, I
record?
have seen it, December 2023.
Get to query.
All right, it's there. So he was found to be a juvenile below 18 years.
Below 18
years.
at the time of incident.
Now, what is to be done then?
Lordship, the ordinary.
Section
court of
15 is
appeal-
there. Also, you kindly go through.
Section
It is
15
2000 Act, section 15. Normally maximum 3 years he can be put behind bars. And he has completed 5.5 years. Date of judgment is 36/17. Maximum 3 years he can be put behind bars. 15G also. 2000 continue. 2000, 2013, 2000 or 2 years ago. Juvenile, 2000 Act continue, 27.
Lordship, may I pray, my lord?
Yes.
Let the copy of the inquiry report be provided to us, matter will be taken up on, because some judgments say they should be released forthwith, some says they should be kept.
Supreme Court
in abeyance.
judgment is there.
There are various judgments.
All right, then you
On Friday,
examine
we
it.
have-
We'll take it up on 23rd.
Yes.
23rd. If he is a juvenile, then the only question is what is the recourse to be
Yes,
followed?
yes.
Lordship,
All right,
that's
heard
Copy
Mr.
be provided.
E. Talukdar, learned counsel appearing for the applicant, also heard Ms. B. Bhuya, learned deputy Assam appearing satisfied. The report of the language sessions that Jalguri dated 13/12/2022 pertaining to the issue of juvenility of the applicant is available on record. According to the said report, the applicant Sona Besra alias Mandal
Wonder.
was a juvenile on the date on which the occurrence took place, that is on 13/10/2013. Mr. Talukdar submits that since the impugned judgment of conviction was passed on 30/6/2017 and the applicant has already spent more than 5 years in custody, he be forthwith released. He be forthwith set at liberty by setting aside the conviction. Full stop. Responding to the above, Ms. Bhuya seeks a copy of the report dated 13/12/2022 so as to make further submission of the matter. In view of the above, let this IA be posted again on 23rd of January 2023 as a fixed item. register to furnish, you also want to
I also want to.
furnish a copy of the report.
He's for the
submitted-
amicus curiae.
I'm appointed as an amicus.
Submitted, then you write,
I can
had
find-
Mr. M.K. Das, learned amicus curiae. Report Dibahun, then Mr. D. Talukdar, etc. We furnish to the learned amicus curiae, comma, the council for the. Acha, then you also write Ms. K. Fukon, learned legal aid counsel appearing for the informant. Copy of the report dated so and so be furnished to learned counsel representing all the parties within 3 days from today, so as to enable them to examine the same and address this court in the matter.
Marks over.
Obliged.
Item 7.
My lord, in this case, step was taken, my lord. Service report is provided.
Who is respondent number 3 here?
There is Millard, he was a co-accused, your lordship.
This is conviction is under POCSO Act,
My lord.
276.
and respondent number 2 is
Along with
With
17.
Informant, your lordship.
why co-accused is a party?
My lord, against him, there is some allegation, my lord.
So this is a criminal appeal. Why is it necessary as a party?
Actually,
Co-accused, he has been
no.
acquitted.
he has been acquitted, your lord.
Then why?
They should prefer an appeal against order of acquittal.
No, my lord, I'm against the conviction, my lord.
That's right.
But there was some dispute between the appellant and the respondent number 3, your
But
lordship.
we'll not go into all these things.
Respondent number 3 is the grandfather of the victim, your lord. Respondent number 3 is the grandfather of the victim, your lord.
So anyway, LCR has been received.
Yes.
Hmm. What to do, service on respondent number 2?
Lordship, service may not be required because victim should be made as party respondent, not the other persons. My lord.
That's right, we'll strike off his name.
Yes,
respondent number.
I think.
What about no unserved notice from respondent number 2 yet?
So Lordship,
Let-
we may take first steps on the respondents.
We take
Right.
fresh steps on respondent number 2.
My lord.
All right.
My lord.
Mr. A. Raman, learned counsel for the appellant. Also had Ms. B. We are learned APP Assam appearing for the state. Peru's office note dated 19/12/2022. Full stop. It appears that the respondent number 3, who was a co-accused in the case and was acquitted by the learned trial, has been impleaded as respondent number 3. Full stop. No, there is office note dated 19/12/2022, which goes to show that unserved notice from respondent number 3 has been received with an endorsement within course, insufficient address. And service report on respondent number 2 is also not available. Full stop. Since respondent number 2 is the informant in this case. And the conviction of the appellant is under the provisions of POCSO Act 2012. Appellant to take fresh steps for service of notice upon respondent number 2 by registered post with ID within a week from today. Full stop. Insofar as respondent number 3 is concerned, it appears that he is a co-accused who was acquitted by the learned trial court. Therefore, we do not find any justification to serve notice or to hear the respondent number 3 in this appeal. As such, the name of the respondent number 3 is hereby struck off from the array of parties. Full stop. Since the LCR has been received, registry to take steps for preparation of paper book. Let the matter be listed again after 6 weeks with appropriate office note.
Obliged.
Item 8.
Yes.
This I has come up for consideration of his prayer for bail, Lordship, and suspension of sentence. Here, Lordship, the
Where's the
appellant-
Yes.
The appellant before your lordship is the husband of the deceased lordship. They got married 2 years back from the date of incident lordship. And allegation is that lordship, the victim was found dead in her house. And therefore uncle of the victim lodged the FIR. Alleging that there is suspicion that they have killed the victim lordship. And thereafter 4 persons family members were named in the FIR. And after investigation, police submitted charges under section 304B. And charges were also framed under section 304B. And after closing the evidence lordship, the matter was fixed for judgment. And thereafter, the learned session judge lordship found that there are ingredients of section 302 and not 304B. So thereafter, lordship, the matter charges was framed under section 302. And the appellant was given chance to cross-examine the witnesses again. And after thereafter, lordship, as the 302 was added, the appellant adduced evidence, although he initially said that he will not adduce evidence. As 302 is added, therefore he also adduced two evidence of 2 DW in support of his plea of LEV. And after going through the records, lordship, the learned session judge convicted the appellant on the basis of that there is no explanation on his first circumstance. And second is that his plea of LEV has failed. On that count, he has been convicted in the present case. Apart from these 2 aspects, there is no material in the record to show that he is involved in the present case.
But has he been acquitted under 304B?
No, that is not observed in the judgment, lordship. No finding is there. Because lordship, it is in the evidence that he disliked her, therefore he tortured her. So there is no demand, that is not there.
Let's assume for a moment that 302 charge is not established,
Lordship.
but the ingredients of 304B are there.
No, lordship. In my humble opinion, not there, because there is no allegation, that not a single line that that there was demand of dowry.
Demand of dowry, it's not on record, but the allegation of torture, there was village Bichar, your lordship. They have taken the plea of alibi, which they could not substantiate. They by way of, they have brought in DW1 and 2, your lordship.
I have prepared one compilation, so we can hand it over.
Compilation will need it during hearing of the appeal. So tell us when you want the hearing. Paper book has been, LCR has been received.
LCR has been received. Let the
See,
paper-
it is a homicidal death.
Yes,
Just,
or the manual strangulation.
But he was not there. That is my case. Lordship. The plea of LEV is there, and even if plea of LEV,
Plea of LEV he took subsequently.
because Lord 302 was not there initially, it was 304B. So it was burden on the prosecution to prove the ingredients for it, that there was demand of dowry, there all these things were there. So he did not initially he did not adduce any evidence. Lordship. Thereafter, when 302 was added, therefore he said that he was not there.
So
But
what is
even
the
on
statement-
record,
what is the
the
fin-
evidence of PW4 is there, he was not there. Lordship.
what is wrong with the finding regarding plea of LEV by the
Clear
child?
value here, Lordship, my submission would be, Lordship, that evidence at section 11 will come here. Because they have to, the prosecution have to say that the plea of LEV is inconsistent with the materials on record. It is not there. I failed, I admit that. But it is not inconsistent with the materials on record, Lordship. My plea of LEV is not a false plea of LEV. It is just I failed. If it is inconsistent, then only it will be a relevant fact. Just I'm taking to your lordship section 11 of the Evidence Act.
No, but you agree that the plea of alibi has failed.
He failed to prove, Lordship. He failed to prove.
That's right. That burden is on the accused. to
Yes.
Prove the plea of alibi.
Yes.
If he has failed,
Lordship.
then that means he could not show that he was not at home.
But if I go to that, to argue that case, Lordship, even in prosecution witness also said that he was not present, Lordship. So I am not going to that aspect, but only my submission to your Lordship is that plea is that fact cannot be taken into consideration as this is not inconsistent with the
Has he,
material
has
from
he,
record.
has he said so in his 313?
Nothing, your lordship,
No,
para
because
18 of the
313
chapter.
was recorded prior to framing of charge under section 302.
No, see. The accused can't be saying if the charge is on this, then I'll say that I was not at home. If the charge is, this kind of, the hyper technicalities will not be entertained by this court.
Lordship.
Is accused persons being let off only on hyper technical grounds. This is the wrong court. We will see substantively. But of course, the charge has to be established.
And
That is another matter.
even if your Lordship sees that 313 statement,
Hmm.
there is no question that that the victim has died homicidal death and you have to explain it. That question is not there. Doctor's question is not there. It is in the record, Lordship, you will find. The doctor's evidence is not put to him that your wife has died after sustaining. That question is not put to him. So homicidal death, that also cannot be taken here as a circumstance because that circumstance is not put to the accused. A circumstance which is not put to the accused cannot rely on by the prosecution. That is also there.
Lordship, may I pray since the essay is there, let the paper book be prepared, your lordship, let the letter be
No,
fixed.
but that, let him first place his case. If he makes out a case for
Well,
bail, we'll grant him. Oh, these are not.
Evidence of DW will be, Lordship will find at page 22.
Page 22.
Yes, before the Lordship may kindly turn to page 13. Page 13, evidence of PW5. May I read it?
Yes, please.
I know the informant Badsha Mondal and the accused person. The occurrence took place about 1.5 years ago. On the day of the incident at about 5 a.m., I heard hue and cry from the house of Sahadat Ali, and accordingly I rushed to his house. Accordingly, I came to know that the wife of the accused Bilal Hussain died. I saw the dead body of Asma Khatun lying on the ground. I have not seen any injury mark on the dead body of the deceased Asma. I made the accused Sahadat, but the accused Bilal was not present at that time. Accused Sahadat is acquitted and Bilal is before your Lordship. So Bilal has taken the plea of alibi, and here also the PW5 said that he was not present when the Lordship he arrived at the place. Lordship. I do not know about the reason as to why and how she died. So that Bilal was not present, that is admitted by PW5 also. And he was at Guwahati, that is reported by
But the occurrence took place before that.
it's about 5:30 if I go by the PM report also. Doctor's evidence. And DW your Lordship will find page 22. I am the Sarkari Gaupura of Tintila village. I know the accused persons who are my co-villagers. I also know Badsha Mondal. On hearing commotion, I went to the house of accused persons and found that the deceased was lying on the ground inside the house and she was already dead. The accused Sahadat Ali could not say about the cause of death and the other accused person was not present, that is Bilal. Accused Sahadat and other family members said that accused Bilal Hussain had gone to Guwahati about 10 days back, but had not returned till that day. He used to work as a laborer. There was no incident of marpit in the house of accused person involving the deceased prior to the affair. The house of informant Bacha Mandal and Jirat Ali are near to each other. I saw some frothing in the mouth of the deceased, but did not see any other injury. Cross. I did not make any statement before the police as Gangura, although I went to the PS. I do not have personal knowledge regarding the accused Bilal being in Guwahati at the time of the incident. I do not know how the deceased actually died. So therefore, Lordship, he said, I do not have personal knowledge regarding the accused Bilal being in Guwahati at the time of the incident. So here, that is why I said, Lordship, before this honorable court, that he failed to prove the case beyond reasonable, but this is not a false statement made by the DW regarding plea of LEV. That is what I was thinking. And then you also will find DW2 at page 23. Because if it is inconsistent with the other materials, then it is relevant. 23. I am the VDP secretary of Village Tintila since last 15-16 years. I know the accused persons and also Bacha Mandal, the informant. On the day in the year 2015, the accused Sahadat called me to his home, and I went and saw that the deceased was lying on the ground and there was frothing in her mouth. She was already dead. Her baby was lying on the bed beside. The parents of the accused Bilal told me that Bilal had gone to Guwahati for work about 15 days back. I have not heard of any incident of marpit of the deceased by the accused persons, and there was no bichar held in the village in this regard. Informant is my next door neighbor. Deceased was leading in peaceful life with the family of the accused. No, I have no personal knowledge about the accused being in Guwahati at the time of incident. I do not know the actual reason behind the death of the deceased. I do not know if there was any dispute between the deceased and the accused persons. It is not a fact that I have come to depose in favor of the accused persons as they are my co-villager. In my humble opinion, this case is squarely covered by the Rina Hazarika judgment notice. In Rina Hazarika judgments also, husband was found dead in their house, Lordship, who sustaining hereditary injuries, and wife was next to her, next to him, Lordship. So in the next day morning, Lordship, the other persons came and found that she was there and dead body is there, and there was no explanation on her part how her husband died. This honorable court convicted the Rina Hazarika, affirmed the conviction, and thereafter honorable apex court said, Lordship, merely non-explanation will not be a ground to convict the appellant. There has to be some other chain of events to show that the accused is connected with the crime. Here also, even if I assume that the appellant was present in the house, there is no other material to show that he is connected with the crime. Lordship. This is my humble submission before you.
Lordship, he is out of his place, your lordship. He is not at his residence. The defense could not prove, your lordship. There should have been some explanation from the side of the accused.
First, let us talk about what the prosecution could prove.
Lordship.
Yes.
Prosecution, lordship, they have lost the FIR. The allegation of demand of dowry is there in the FIR itself, your lordship. From the inception of marriage, your lordship, when the marriage has taken place, that time also they demanded dowry, your lordship. It's there in the FIR itself. And subsequent to that, there was bichar, there was the allegation of torture.
Conviction is under 302.
302. Yes.
302, what
As well
ingredients
as,
have
let
been
me
proved?
see your election. Yes, 302.
What are the ingredients which have been proved?
Lordship, it was a homicidal death, your lordship, as per the report of the doctor.
Yes, yes. Apart from that,
And apart from that, your lordship, the allegation of the demand of dowry was there earlier, my lord, in the FIR, but the prosecution witnesses, they did not say anything, if I'm not wrong, your lordship, as regards the demand of dowry, your lordship. But there was a torture prior to the occurrence, and there was village bichar, your lordship. And the informant was informed that the deceased was killed by her husband, Bilal Hussain, my lord. But naturally the witness,
Informant was informed by whom?
by one Badshah, your lordship.
How did he know? He was present.
Lordship, Badshah, it was an PW now.
PW1. Badsha control is PW.
Informant. Then, where do you move?
PW1.
In the appeal memo, your lordship will find at page 10.
Para 18 onwards, para page 21, my lord. Lordship, evidence of PW7, may I take your lordship to evidence of PW7? I know the informant accused person. The incident took place about 2 years ago in the morning time at Tintila. About 5 a.m., accused Sahadar Ali came to our resident and invited me to his house, saying that some serious incident occurred in his house. Accordingly, we went to the house of accused Sahadar Ali and saw the dead body of Asma Khatun with Bilal. This is Asma Khatun, wife of, I'm sorry. The deceased Asma was my niece. I saw the dead body of Asma Khatun on the ground that there I returned home. Cross decline. No, I'm sorry.
These things have been established.
Yes,
He died of homicidal death.
yes,
It was in the matrimonial house.
yes.
Correct. And the dead body was seen in the morning 5 a.m.
Yes. My lord.
Apart from that, what else has been established?
Apart from that, the allegation of torture, your lordship, it was there. It's on record.
Where is the evidence?
Evidence is there, your lordship. The evidence of PW2, he tortured her, a meeting was held. PW2, Ibrahim Khalil.
Have you given PW2 in this paper?
Yes, yes.
Lordship's voice is not coming up properly.
Page 7 is the PW2. Page 7.
Then the evidence of PW6, my lord, Nuru Mondal.
Mr. Ahmed, we would like to have the paper book and then you have to wait. At this stage, not inclined. Not rejecting your application, you have to wait. LCR has been received.
Only my parents, because lordship, only non-explanation that is there. Apart from that, there is no material to connecting with the case. Because that is squarely covered by Rina Hazarika's case, lordship.
That's right, we'll set equity. Give him equity if that be. We want to have a full view. What was his explanation? In 313, what questions were put? These are things we have to see. Technicalities are always there because we have been saying our prosecution and investigation is very, very poor.
And
But
other
then we can't go hyper technical in these things. We have to see.
the circumstance that she died homicidal death, that is not put to the accused in 313. That circumstance also they cannot rely on now, lordship.
So what are you saying? How did she die?
No, they have to first prove, lordship, that homicidal. that
Heard
is not-
Mr. Yamil, learned counsel for the applicant, also heard Ms. BBL learned APPSA appearing for the state. After hearing the submissions of learned counsel for both the sides, we are of the opinion that the issues raised by the applicant touches upon the merit of the appeal. As such, paper book will be necessary for considering this IA. We accordingly defer consideration of this IA for 4 weeks with a direction to the registrar to expedite preparation of paper book. Let the matter be listed accordingly.
May I pay for that any date after 4 weeks? lordship? Any date after 4 weeks?
All right. Let this appeal be listed again on 8th of February.
Item 9.
Maybe legal also. This IA application 481 of 2022.
Hmm.
And application under section 381, 389 of one of the CRPC. For suspension and sentence to release the application on bail. The LCI is already received your lordship. I see. So Maham to some let the matter may be fixed for hearing, or if this lordship permit, then I will argue. It's quite convenient.
There's nothing to permit or not to permit. You tell us what you want, we'll pass an order. accordingly.
Paper book.
Lordship, here in this case, I seek for bail because one son is with the accused person, then whereby wife. So for the mother is concerned of that son who's left the house. So he's the only son and father of the deceased, father of the son. The humble submission is that if lordship permit.
So why are you again and again saying permit? We don't stop anyone from arguing anything.
Here in this case, your lordship, what is happening? The order had been passed by this trial court of Tinsukia, district session judge,
Hmm.
in the matter of person 22/6/2022 by the Tinsukia session judge, your honor.
Mhm.
And accordingly, judgment and order dated person 22/6. The whole case is based on circumstantial evidence. And on the basis of the circumstantial evidence, the appellant has been convicted under section 302 IPC.
Hmm.
Here in this case, your lordship. Okay, can you put it? Give me a lesson. There are about. If you lordship, go to the judgment passed by this honorable, but the learned trial court,
Accused is the husband of the deceased.
husband. There are about 11 witnesses, your lordship. If you lordship permit us to one page 149.
My learned brother would like to take up this matter. List this case before any other bench without one first. Make it justice. Soika Savan included.
Item 10.
May I please, Lords? My Lords, from the office note, it appears that though notice has been sent on 15/11/22, that is more than 39 days, respondent has not appeared nor the ID card has returned. Now my submission is this, my Lord, perhaps she may not be interested, the party, 39 days already passed. So my prayer for bail may kindly be considered by them.
What is this, POXO?
No, this is 76.
Three?
76. Informant husband of the victim woman. Ranjita Bhushan. Victim.
Lordship, fresh steps be taken in the matter.
Fresh step not retaliation. Better, my lord, may kindly appoint an amicus curiae.
All right. Will appoint a legal aid counsel. Heard Mr. M. Mahmood, learned counsel appearing. Also heard Ms. B. Bhuya, learned FPP Assam appearing for the state. The conviction of the applicant in this case is under section 376 of the IPC. That stop taking note of the same. Notice was directed to be served upon the respondent number 2 stroke informant, who is the husband of the victim.
Who is the victim itself?
No, informant is the husband, but here we have met the victim as party.
And so, taking note of the fact that the respondent number 2 is the victim in this case. Notice was directed to be served upon her by registered post with ID. Accordingly, command notice was also sent. Stop. No service report is, however, available on record. Considering the urgency expressed by Mr. Mahmood pressing for early disposal of this IA, we deem it appropriate to appoint a legal aid counsel so as to represent the victim stroke respondent number 2 in this case, the registry to do the needful. Let this matter be listed again after 2 weeks by reflecting the name of the legal aid counsel in the cause list.
One clarification regarding or mentioning yesterday by my junior, what happened? The matter was urgent. We mentioned it before the court number 1.
Please tell your juniors not to tell lie because we are not.
He became nervous showing your lordship.
But we inquired, there was no such recommendation made by.
That is, I am giving the explanation. We mentioned she mentioned the matter in court number 1. Then court number 1 said, I am on the way to go. So you mentioned in court number 2. In the meanwhile, matter started. Then we were expecting that at 2 that will sit. But at 2 p.m. court number 2 did not sit. Then I said that you go to court number 6 and explain the matter. Thereafter mentioned, but he became nervous. So I am sorry for that. All right.
Timely matter item 4.
Lordship, may I pray, since Miss Jahan was dealing with the matter, she is not keeping well, your Lordship, may I come up on Monday?
Or immediately after vacation.
Heard Mr. T.H. Hazarikal as the counsel for the applicant. Also heard Ms. V. Bhuya learned FPP Assam appearing for the state, who submits that this matter is being handled by her colleague, Ms. S. Jahan, bracket APP Assam, bracket close, who is indisposed and therefore could not come to court today. Full stop. On such ground, a pair has been made to pass off the matter for the day. Full stop. Responding to the above, Mr. Hazarika prays for posting this matter again on 23
Yes,
1/2023. Prayer allowed, register to list this case accordingly.
deeply obliged.
Supplementary is for order item 14 and 15.
May it please be further. My lord, I am before appeal against conviction, my lord. And in this regard, I have filed on this case for suspension of order passed by the learned trial court, my lord.
Yes.
And my case is, my lord, informant Amir Rahman, who is also the grandfather of the accused, my lord. You know, accused number 1, Hafizur Rahman. And their case is that we, along with my co-accused, killed the deceased, but my case is, my lord, the deceased was alive when we left the house of Mr. Amir Rahman, the informant. My lord. This is the nutshell of the case, my lord, and the summarily, the appeal was reflected in the para 3 of my 451, the bail petition, my lord. Means this,
Para 3 of your application.
my lord. The ground of the appeal also reflected in the para 3, my lord.
Just take a seat for a minute.
My lord, my lord.
See, Ms. Sharma,
My lord.
this is something we would like councils like you to take note of. The case you have projected in your bail application
My lord.
is the final argument you will make in an appeal. Correct?
No, my lord.
So these are all about this evidence that bail is, if you don't get a, if you can't convince the judge in first 2 minutes, you don't get a bail.
My lord.
This is the norm.
My lord.
There should be something which is so apparent on the face of the record that it creates a genuine doubt
My lord.
in the mind of the court whether if this is correct and which appears to be correct from the materials on record, then there is every likelihood that the conviction may be set aside.
My lord.
Otherwise, going to a full-length story, this happened, that happened, he went there, she came there, he saw this. These are, of course, matters which will immediately take the case to the final hearing stage.
my lord.
So in 2 minutes, tell us what is the ground on which you are seeking bail. Then
My lord, first of all,
you give the particulars later.
my lord. My lord,
First, you have to tell us
my lord,
that this is what has happened, that is what has happened.
my lord. Deceased is my husband, appellant's husband,
Hmm,
and one baby is also in my lap.
hmm,
And I, along with the co-accused, went to the grandfather's house of the co-accused. Just for roaming, my lord, nothing else.
Hmm.
And my husband consumed liquor, my lord.
hmm,
And so he unable to walk.
hmm.
Then that is why he is lying on bed.
Hmm.
And when after some time, when we left the house of the my co-accused grandfather's home, Amir Rahman, then he was alive, my lord. Alive, and the other lady, more particularly, PW6, my lord.
Hmm.
Her examination, namely Jaheda Khatun. She herself in her cross stated that deceased was alive, and he spoke that where I am, because he consumed very much of liquor, he is unable to know where about him. And we leave him because he unable to walk. Then the co-accused bring 2 persons after a few time, and then he saw that person was dead. Accused was, but deceased was no more.
And what does the postmortem report say?
Postmortem report, my lord. said-
Asphyxia.
Reflex-
Asphyxia as a result of strangulation
Hmm.
and homicide and antemortem.
So both accused, both appellants, both have filed application for
My
bail.
lord, my lord.
Two, yes, and they were there, they have admitted in 213, they were there, they had brought the body. That time he was alive,
Mm.
and they kept in the grandfather of the Hafizur, the other accused person, and they went away. And one of the factor is that, your lordship, both these accused persons got married subsequently. Lordship, and lordship, there was leading to discovery of the rope.
Rope.
Yes.
Who led it to discovery?
This accused person as part of evidence of.
Both of them.
No, this Hafizur, other one.
So what is the material against first applicant,
No material, my lord.
Zahida Begum?
Jahida and this Hafizur, they came together.
Hmm.
They kept the body in the residence of the grandfather of the Hafizur. Then they went away. Then later on, they have taken the plea that lordship, he was taken alcohol, lordship. That's why he was kept there. Later on, this accused person Hafiz was apprehended by the public.
So, but when the applicant left the place,
Yes.
then the victim was alive.
My lord.
One of the witnesses said
PW6.
PW6.
Her statement is here.
Yes,
My
and even this one of the accused persons says in 213, they asked him where they have brought him. This deceased asked them where they have brought him.
Where is PW6 statement is there?
My lord, 18 to 19, my lord. Paper book, my lord.
Give the paper.
Lordship, and there are 164 statement of PW6 is also there, but I didn't find it in the paper book, your lordship.
Page 18. Page 18, did you say, Ms. Sharma?
My lord. My lord. My lord. On oath, my lord.
Yes, where is it?
May I read, my lord?
Yes. Come to the relevant point, that's all.
My lord, my lord.
Hmm.
I know the informant, middle of the part, 15, I asked SMT Jaheda to what happened. Then the accused SMT Jaheda told that this person lying on the bed is her husband, and that her husband become ill, as such he was lying on the bed. At the time, the person who was lying on the bed spoke and asked the accused person as to where he had brought him, to which the accused person asked him to keep lying down, and thereafter I returned back to my house. This proved, my lord, that he was alive and he was.
PW2 also says they were there. There are eyewitnesses who have revealed their lordship. These accused persons came in auto rickshaw.
No, she is saying that after the applicant left, somebody heard the deceased speak. Is this PW6? She doesn't say so.
It was there. At that time, The person who was lying on the bed spoke and asked the accused person as to where they had brought him, to which the accused person asked him to keep lying down and thereafter returned back to my house. Lordship, her husband is lying there in whatever state. The injury was also found. Some of the witnesses have deposed and she left, my lord, along with this other co-accused. See the conduct, your lordship. And subsequent to that, she got married with the other accused person.
Because my lord, he is unable to walk, my lord. That is why in the co-accused also informed that they.
And there was injury as per the evidence of PW2.
Conviction is under which provision?
302.
Only 302.
34.
And where is the finding of common intention?
Lordship, para 59, page 68.
No, what we are asking is, has anybody seen the deceased alive after both the accused or one of the accused had left the
Yes, my
place?
lord, PW6, my lord.
Where is it? That's what we are asking you again and again.
Lordship, PW6, page 18. At that time, the person prior to that asked Jaheda as to what had happened, and then the accused Jaheda told that the person lying on the bed is her husband, and that her husband became ill, as such he was lying on the bed. At that time, the person who was lying on the bed spoke and asked the accused person as to where had they brought him, to which the accused person asked him to keep lying down, and thereafter I returned back to my house. But there was injury, your lordship, as per the evidence of PW2. Injuries were seen, my lord, on the body.
So that still does not answer our question.
Lordship, that as per the evidence of
So
PW6,
is it not possible that after PW6 left, then they strangulated him?
Maybe, my lord, but all are circumstantial.
lordship, it's a lordship, the time gap is not more. They were very much there at the time, my lord.
You are arguing in favor of the defense.
No,
The
no.
defense is arguing in favor of the.
No, your lordship, my
to do?
contention is that, your lordship, time gap when they left, because at that time PW1 was very much present. Wife of the informant. She saw, then she informed the other members who happened to reside in their land, my lord. They informed PW2 also. They saw injury mark.
Paper book is ready. We'll have it for hearing.
Lordship.
Yes, yes. We'll fix it for final hearing and
Yes.
finish it up.
My lord, I am submitting in my bail application, my lord. May I submit, my lord?
You can submit, but we're posting it for final hearing on 2nd of February.
My lord.
Lordship, 164 statement is not there. Let the registry provide Because in the paperwork I have did not
One
find it.
sixty-four statement of.
Or PW6.
All right, you take down hard, Ms. B. Sharma, B. D. Sharma, Leonard Legal Aid Council, appearing for the appellant in criminal appeal number. You are for the appellant in 81, Ms. Sharma, and Mr. DJ Hanan, Leonard Council, appearing for the appellant in criminal appeal number 36 of 2022. We have also heard Ms. B. Dhia, Leonard Senior Counsel, bracket APP Assam, assisted by Mr. J. Das, Learned Counsel, appearing for the state in both these matters. First up, the appellants, the Learned Counsel for the appellants have pressed into service the respective IS filed on behalf of their clients, seeking an order of suspension of sentence and also for release of the applicants on bail. First up, both the counsel have also addressed elaborate arguments in support of their plea. First up, Ms. B. Bhuya, Learned APP Assam, has opposed the said submission. First up. However, after considering the submission made by the parties, we are of the view that instead of taking up the IA, the appeal itself deserves both the appeals deserve to be heard and disposed of at an early date. Since the appeals have already been admitted and the paper book is also ready, we direct the registry to list the appeals for final hearing on 2nd of February 2023 as fixed items. A registry to also trace out the statement of PW6 recorded under section 164 CRPC and place it on record. The IAs shall be kept pending. The IAs be kept pending and shall be considered at an appropriate stage. Yes. So, Ms. Nargis, you have a hearing matter, is it? Which item is it?
69, Lordship. 69.
We'll take it up tomorrow.
We are not there, NCB.
NCB. We'll take it up tomorrow. There is another bench today and we can't handle both. So we will definitely finish off a parted matter rather than start something new. Let us see. Tomorrow you take a chance. You inform the other side.
Tomorrow, Lordship, fix another Pradhan matter.
Today.
Tomorrow also fix, Lordship. Yesterday's matter, Lordship, Miss Sahan could not
We'll
appear.
take it up. What to do?
It's
We
up
can't
to-
help it. If tomorrow also, if it is not possible, then it will go to another day. We are hearing cases and delivering judgments. Can't be helped.
No, that Lordship is taking up lots of matter. Also.
No, we have to go one by one and finish off the cases.
We for that we are very grateful to your Lordship.
No, it's all right. But
It's a.
we appreciate your clients' predicaments.
But it's a 2019 matter. That is why I am pressing it because one of the petitioner's wife is suffering from cancer. That is why we mentioned before the Honorable Chief Justice Court also.
We'll take it up tomorrow. We'll take it up tomorrow. You come prepared.
Obliged, Lordship.
Yes, you inform the other side also.
Lordship.
12:50.
The materials.
Hmm.
So before I take your lordship to section 18 of the UAPA, I would like to place the definition. Section 2, definition 2L. In fact, one definition comes at section 2, subsection EC, person includes an individual, but I will not harp upon that because this is a recent edition of 8 August 2019, that a person includes an individual, company, firm, organization, artificial, jurisdictional person, agency, etc. So I'm not on individual. I take your lordship to 2L, terrorist gang. Terrorist gang means an association other than terrorist organization. This very vital thing which was missed out at the trial court. Terrorist gang means an association other than terrorist organization, whether systematic or otherwise, which is concerned with or involved in terrorist act And what is terrorist organization? M. Terrorist organization means an organization listed in the first schedule or an organization operating under the same name as an organization so listed. So a terrorist organization, CPIL Maoist, they become a terrorist organization on 22nd June 2009. So they will fall into the category of terrorist organization since then. But prior to that, whether it is KMSS or CPIML, it will be a terrorist gang. So if they do not fall under this list, schedule first list organization, they can still be considered as a terrorist gang. Then unlawful activities, O, that is given there. Unlawful association, we are not concerned. And unlawful association is declared under section 3. Section 3, declaration of an association of unlawful. In our case, it was on 22/6/2009, where the members of the KMSS were trained, that is CPIML in Orissa. That association which imparted training became unlawful.
Organization declared under section 30%, association 30% declared.
Okay. Now coming to the relevant
Unlawful on, which is the date?
22/6/2009. In the statement of this protected witness B, he mentioned about the year 2009 and prior to that also. But 2009, whether it is post 22nd June or prior to 22nd June, that is not visible. So now I am coming to the punishment for terrorist activities. The provision is section 15, Terrorist Act. What constitutes a terrorist act? Terrorist Act, whoever, so in this case, whoever is a very wide term. Whoever does any act with intent to threaten or likely to threaten the unity, integrity, security, economic security, which is relevant in our case, or sovereignty of India, or with intent to strike terror or likely to strike terror in the people or section of the people of India or in any foreign country. I am skipping A. I'm not skipping A. A, the first part is not relevant. Although I'm reading it. By using bomb, dynamite, or other explosive substance or inflammable substance or firearms or other lethal weapon or poisonous or noxious gases or other chemicals, or by any other substance, whether biological, radioactive, nuclear, or otherwise, of a hazardous nature, or by any means, this is what is relevant in our case, or by any other means of whatever nature to cause or likely to cause. What? One says death or injuries to any person or person. In our case, it is injury to the police officer. Loss or damage or destruction of the property. Railway station burned down, offices were burned down, government vehicles were burned down. Loss or damage or destruction of property. C, Roman 3. Disruption of any supply or services essential to the life of the community. Trains were stopped, roads were blocked. Disruptions of any supplies or services essential to the life of community in India or any foreign country. And Roman 4, damage or destruction of any property in India or in foreign country used or intended to be used for the defense of India or in connection of any other purpose of the government of India or any state or any other agency. So destruction of property here. Then section 18. 18 says punishment for conspiracy. Whoever conspires or attempts to commit or advocates, abets, advises, or incites, directs, or knowingly facilitates the commission of a terrorist act or any act preparatory to the commission of a terrorist act shall be punishable with imprisonment for a term which shall not be less than 5 years, but which may extend to imprisonment for life and shall also be liable for fine. Very wide area of operation of this provision. Who conspires or attempts to commit or advocates, abets, advises, incites, directs, or knowingly facilitates. All these telephone calls I will now come will indicate that there is a conspiracy going on. Then section 39. Section 39, offenses relating to support given to a terrorist organization. In our case, they are helping CPI-M Maoist. A person commits the offense relating to support given to a terrorist organization who, with intention to further the activities of a terrorist organization, invites supports for the terrorist organization. 2. Support is not or is not restricted to provide money or other property within the meaning of section 40, or who, with the intention to further the activity of a terrorist organization, arranges, manages, assist in arranging or managing a meeting which he knows is to support the terrorist organization, to further the activity of the terrorist organization, or to be addressed by a person who associates or professes to be associated with the terrorist organization. All the names I read out from the statement of protected witness A and B, the names are very clearly given there. Who are the leaders of CPN who came to visit Assam, Golaghat, Dibrugarh, Guwahati, and who were responsible for taking the batches of KMSS members to Odisha for training. A person, 2, section 39(2) says, a person who commits the offense relating to support given to a terrorist organization under subsection 1 shall be punishable with imprisonment for a term not exceeding 10 years, or with fine, or with both. So these are the provisions. I am not placing the other provisions of the IPC. Those are equally stringent. Section 120B, that is conspiracy. Lordship knows it very well. Then 124A, at that point of time, 124A, Supreme Court had no restriction. Now also Supreme Court says that the court expects that cases will not be registered under 124A. That is an aspect, that is not a mandatory, but this was case belongs to the prior to that.
That order has been altered, or it is?
It is that the hearing has not taken place. In any case, when the hearing took place for the framing of charge under section 227 of the CRPC before the trial court, at that point of time, these issues were not there. On 1st July 2021, this happened in 22, all these subsequent developments. Now, then the other section is 153A, promoting enmity between different groups on ground of religion, race, etc. 153B, imputation assertions prejudicial to national integration. So these sections are already there. Apart from that, the UAP stringent sections are added.
What are the, you just repeat the IPC sections?
IPC sections are 120B, 124A, 120B, 124A, 153A, 153B. Even for assumption that they do not come under the UAPA provisions, if 18 or 39, these sections still are there. That is why it is not a case for discharge. The special judge could not have tried it. He could have sent it back to the normal sessions court for trial. But en masse, all the provisions are not there. NI is not that agency, Lordship, which does the investigation in a very casual manner. The records which I am going to place today, that will very clearly indicate that they were very serious in their investigation and all the materials are scientifically based. So I'll place those materials before this honorable court. Lordship will take the documents bunch. It starts from D1 to the original records.
These are what, part of charge sheet?
Parts of charge sheet. That is why it was very shocking that previous day the case was closed and next day morning at 10:30, the whole judgment was delivered. Very shocking. I should not be that harsh, but the situation, the turn of events made me utter those words. First, Lordship would kindly see D13/1. seizure list.
Yes.
These were the documents which were seized. Lordship will kindly come to D14. Communist Party Istahar. These are all seized from their offices. Karl Marx, Friedrich Engel's book. Then 2 Lenin's book. Then D Marxbad Ki, Emil Burns, Mao Zedong, New Rupot Gonotantra, Prokashok Krishok Mukti Sangram Committee. Then Kalponik and Boigyanik Samastantra, Friedrich Engels, Introduction to Socialism. All these materials were seized from their offices. Then page it will be 13/19, 8. The contradiction on practice, Mao Zedong. Akomia Bhangoni Udoyaditya Bharali. Then Stalin's book. All these were seized regarding the materials, which shows the ideological thing. Because CPI-ML, we have to connect it with that. So this KMSS, although it is a farmers organization, these are the ideologies. And these ideologies can be directly linked with CPI-ML Maoist, which is a banned organization as on date since 22nd June 2009. Next, D15. Request to provide lawful interception of phone calls of accused Akhil Gogoi and others. So proper process has been done to do the interception. Next page also, D16. Mihirjit Gayan said with reference, I am enclosing here one DVD containing legally intercepted voice calls and transcripts of accused Akhil Gogoi, Dhorjo Kaur, Bittu Sonwal, according to the guidelines of MHA under section 5(2) of the Indian Telegraph Act 1885. Then the certificate of Mihirjit Gayan, SP, SOU. Then certificate under 65B, page D18. So whatever interception was done, it was done as per the provisions of the Telegraph Act. Now, what was the findings of the interception? Page D34/1. The translation, original transcriptions, the translation is done by, that is second page, Anubhav Multilingual Service. Because the conversation was in Assamese and it was translated, which I am going to place before this honorable court. So this is to certify that my firm Anubhav Multilingual Services, Sector 2, Noida, has been appointed as official translator for carrying out the translation of documents of National Investigating Agency, Lodi Road, etc. We have accordingly carried out translation of documents from Assamese to English language. These documents are provided to us for translation by NIA by letter dated 11/1/2020. We certified that the Assamese to English translation of documents are true and correct to the best of my knowledge. Now the transcriptions are in Assamese from page, although English, that is Roman letters are used from 3 onwards. I will come to the translation part, which Lordship will find at C 41. The Assamese are in the first part, that's translation parts. With a seal at the bottom. Have Lordship got it? Page 41. Akhil Gogoi with Arup Chandra Borbora.
Yes.
There, they were conversing what should be their planning, how to oppose the Prime Minister Narendra Modi's visit to Guwahati and how to welcome the Japanese Prime Minister. One paragraph from there I would like to read. 4 paragraphs from below, Arup Chandra Borbora. First thing first, is that Shijo Abe will come to Assam and appeal. Only you can do it. Prepare 10,000 posters mentioning Shijo Abe most welcome to Assam. Narendra Modi go back, the anti-community go back. Do you know what will be the consequence of this? One international press team will come along with Shinzo Abe. If they will click at least 4 posters and the publish on their international media, then we may get international support. You have to attach all the posters by late night. You can do it. I know. We have did such activities during the time of Assam movement. Shinzo Abe most welcome to Assam. Narendra Modi go back. The anti-community go back. If the press team will click at least 4 posters and publish on their international media, we will get international focus on the issue. I have just given you an idea. Akhil Gogoi said, okay, fine, done. So this is a campaign against the existing Prime Minister of the country. That is the government of India. Who were conversing? Orup Chandra Borbora and Akhil Gogoi. Whoever advocates, incites, this is one ingredient of section 15. Read with section 18 of the UAPA. Now coming to
The Arup Chandra Borbora advocate.
yes. Lot of people's conversations are there. Government is still not taking everybody on task. All the records are there and all these interceptions were legally done. Page 44, Akhil Gogoi with Dhoirjo Kaur, one of the accused here. 4th line, Akhil Gogoi said, okay, Dispur last gate, do the people in large number gather there? How many people are there? Dhoirjo Kaur said, not much, around 500, around 550 people. With these people, do something in a positive way. Positive way will come little bit later. What should be done? Please tell. Do something to get positive result. Do the people enclose the house of Himanta? Yes, the people are enclosing the house of Himanta. Persons where? Dhoirjo Kumar said at his Jew Road residence. Good, just do it. It's a Nike word, just do it. What should we do now? I have no idea. Do something in a positive way. There are not much people, around 300 people are here. This is one conversation. The next, Akhil Gogoi with Deepjyoti Sharma, page 45. 3rd line, 4th line, Deepjyoti Sharma said, people in a great number gathered here, around 5,000 and more people will come. Akhil said, are they coming? Yes, they are coming. I hope around 20,000 people will gather here. Akhil said, good, do close everything. Yes, we have stopped everything. Yesterday, we visited each and every hostel. Akhil said, where? All the girls hostel, JSC College, Prince Para College, not clear, IPS hostel, BCB, JCB. We almost visited each and every hostel. Did our workers come? Yes, I saw them. Deepjyoti Sharma, you have to come. Akhil said, no, actually, I came to Tinsukia. I promised them before I would come to Tinsukia and therefore I have to come to Tinsukia. Deepjyoti said, is there any problem in Tinsukia? Akhil said, yes. At Tinsukia, one program will be held, not clear. After that, one meeting will be organized. After that, Dharna program will be carried on at Chabua. Then I'm keeping 3 lines later. Akhil said, will all students union join? Yes, all students union will join. Okay, good. Don't lose hope. Continue the struggle. Yes, we'll continue from Jorhat. Don't worry. Okay, it will be fine. Yes, it will be a larger than the previous one. People participate in a large number. Akhil said, good, very good. Deepjyoti Sharma said, yes. Now 47. Conversation of Akhil Gogoi with Deepak Mudoi. 5th line. Akhil Gogoi said, I am in Dibrugarh. Deepak Mudoi. What will be the agenda for the Khatri Sonapur area for tomorrow? Please give us an idea. Akhil said, Khatri Sonapur area means just close everything, block all roads. So this is very critical. This is a very important statement from Okhil Gogoi that just close everything, block all roads. Section 15, Terrorist Act. Deepak Mudoi said, yes, Okhilor logot kotha patok. Please speak with one of our leader. Please talk to Okhilda. Third person, brother, namaste. Okhil said namaste. Third person, yes, we will obstruct all roads tomorrow. Okhil Gogoi said, all roads across the state Assam will be blocked tomorrow. You must come out early morning to do this act. Third person says, yes. Okhil said, all right. We'll block the national highway, complete block. Okhil said, yes, complete block. Third person says, around 400, 500 people will gather at Khetri. I am speaking from Khetri. Okay, good. Yes, all people went on torchlight march, around 200 to 300 people. Okhil said, yes. Third person says, okay, we'll do it. Okhil said, just do it. Then coming to page 49, Okhil with Deepak Mudoi, last 3 lines. Now we have to block everywhere in Assam, he told Deepak Mudoi. Stop everything. No other issue is important right now. Deepak, we are doing here, just advise us what to do. Okhil said, we have to block everywhere in Guwahati, stop everything, ready for any kind of protest. All right. Then page 50, Okhil with Gopal Das, that was on 11 December 2019. Third line, oh, Borhia, Bahut Sohor Manu Ahile, 20,000 uporot ahile. Hello, good, thousands of people, around 20,000 or more than that. Then Gopal Das, few lines later, thousands and thousands of people are gathering in Janta Bhavan, go there. Okhil said, we'll go to Janta Bhavan means you will go from here. Here it means in 3 or 4 places it was done in Guwahati from starting. Okay, go to Janta Bhavan now, Janta Bhavan. Are you coming from there? Will be done there somewhere tomorrow. Okhil said, Apuni, you won't do anymore, or you will do it somewhere, Dergaon, Sergaon. There won't be any program in these places. Okay, this Gopal Das said, now I am on way to Jorhat to inform the boys. So they were planning something in Dispur area here, the conspiracy part. And in Dispur area, 5 vehicles were burned. All government properties on the roads were damaged. They were planning to attack the secretariat. At that point of time, police intercepted. Then next page. Page 51, it was a conversation, Okhil and Joyanta Das in the middle portion of upper side. Joyanta Das, Okhil da hoine, is it Okhil brother? Third person's hoy. Apuni koisil sob stobdo kori dibo lage, ami hauli borpetar sob stobdo kori dilu. You told everything should be stunned. We stun everything in Borpeta Hauli by burning tires. No car can enter. Apuni Hauli le Edin Ahok. Then they mention about Bengali people, etc. in the later part of the conversation. Now coming to page 53. Okhil Gogoi with Mridu Pawan Neo. This is a very important document, Lordship. This as well as the subsequent two. Mridu Pawan Neo, Dada. Okhil Gogoi said yes. Mridu Pawan, the president may not come for meeting between Japan and India on the 15th. This has been discussed at the Home Ministry today. They are afraid of you and apprehensive of facing a very threatening movement in Assam. This information has come from inside sources. I am just bringing this to your notice. Mridu Pawan further, I mean the meeting may not happen taking into account the opposition to CAB. Your name came into the discussion may be because they have declared the movement here as very militant. If such a thing happens before the president of China, sorry, Japan, India will be shamed. This is the reason they don't want the meeting to be held, so the president may not come. I am just keeping you informed. Skipping 4 lines. Then Mridu Pawan, I have been watching live. had been observing for an hour waiting near the secretariat. It is me who sent Mia Baido telling her Baido, go, no point wasting time waiting or writing on Facebook. After she left, I phoned you, Dhojjo, who told me he had met with Baido. Then last line, let something happen. I will get something done tomorrow. We'll give it to Dhojjo. Yes, I will be at home. So they were saying, let something happen. I will get something done tomorrow. And what is that tomorrow will come now. Then next page, another conversation between the same two persons. The earlier was of date 5/12/2019. Then the next one is 11/12/2019, after 1 week. Mridu Kumar, Mridu Pavan Neo. Hello, remember me telling you so many days that president will not come. Okhil asks who? The president of Japan. He is not coming. Absolutely confirmed. Just don't hold on of the movement. It is a critical situation here in Assam if it is held off. Then skipping few lines. Mridu Pavan. The situation overall, the crux of the matter is please don't turn away from the agitation. Okhil said, what happened in Guwahati today? In Guwahati, police buses were burned down. The secretariat was gheraued. The employees came out of the secretariat, gave the call Joya Offham and protested. So police buses were burned down here. Okhil said, how many buses were burned down? How many? Quite a few. 1 bus, 1 truck, and if smaller cars were included, it was 5 in total, right in front of the secretariat. Is that so? Mridu Fukan says, Mridu Nayak says, even now about 15,000 people are sitting near the secretariat. I have just come from there. They are sitting still there. Next page. Mridu Pavan Nayak says, oh, absolutely, everyone is saying don't let the movement get derailed, meaning if it gets lax, they will get the opportunity. If they get the chance, the government. So here,
Who is this person? Baido?
Baido is, I think, I should not say, it is not sure about it. In the trial, it could have come out, but I know who is.
All right, all right.
Next line, they says, Mridu says, everyone is saying, don't let the movement derail. That means it was addressed to whom? To Okhil Gogoi. That don't derail the movement. That means who is leading the movement? Who is the leader? The learned trial just says he was not involved in burning. That is why he should be given up. He should not be charged. Then what is the meaning of conspiracy? Lot of extremist leaders, they are in some foreign countries and lot of killings happen in Assam. Are they not charged? They are the kingpins, they are the masterminds. So here this conversation clearly indicates who was behind the show. Then few lines down below, Okhil Gogoi says, I have been to Tinsukia, Dibrugarh, Sibsagar, Jorhat, arrived in Jorhat now. Then another, Mia Baido, I have been observing now praying in Gosai Ghar, Holy Sancta, may God keep you well. Okhil Gogoi says, absolutely, thank you, thanks a lot, Baido. Mia Baido, apart from that, I will help as much as I can. You just don't worry. Okhil Gogoi said, you just don't let people get lax going forward. We have to break their government. This is a very important statement, Lordship. The government has to be broken. And what does Section 15 says? Breaking the government. Section 15 very clearly says, whoever does any act with intent to threaten or likely to threaten the unity, integrity, security, or sovereignty of India, economic security of the country, sovereignty of the country. Now, One argument be that whether sovereignty and government are same or not. In a broader way, everything falls under the same basket. So here says, just don't let the people get lax. Going forward, we have to break their government. No, not all through the day will create chaos and continue the agitation. So chaos and agitation are two different things. Agitation, Gandhiji was also doing agitation. ASU was also doing agitation. We are not saying that those agitations come under the UAPA, but in the agitation where public vehicles are burned down, offices were torched, railway stations were damaged, police officers were tried to be killed. Those are not agitations which will come under the realm of non-violent agitation. Here, this particular lady who is conversing with Akhil Gogoi says, no, all through the day will create chaos and continue the agitation. In this chaos, lot of meanings can be discerned. Coming to the next page, Akhil Gogoi with Nobo Moran. Not very relevant.
Is she accused, co-accused?
Who?
So-called lady?
I don't think, but it was open because our investigation was not complete. On 29th, on 1st July, the judgment was delivered, discharging. On 29th also, we submitted additional document. In our charge sheet, we have very categorically said that this conversation, the voices, it was sent for testing in the laboratory. Those reports came on 7th of July. In our charge sheet, we have very categorically said that we are awaiting the reports from the forensic laboratories. And apart from that, during the trial also, 8/7/2021, these voices, in the charge sheet, we did not have this certificate. We have said we are awaiting the report. These voices today, I can very firmly, I can say that the voices belong to Akhil Gogoi, Dhoirjo Kaur, and etc. This report came on 8/7/2021. The impugned judgment is of 1/7/2021. Here, if Lordship comes to the last pages, XVI, that means 24. The specimen voice samples of Akhil Gogoi, Dhoirjo Kaur, Bittu Sonwal provided in exhibit so and so, market so and so. The question voice samples of so and so have been analyzed and compared with the specimen voices of Akhil Gogoi, Dhoirjo Kaur, etc. Using has been found that the question voice sample found similar to that of the specimen voice sample. So today nobody can raise any doubt about the authenticity of these interceptions. That is why it is a very highly technically done investigation. It cannot be brushed aside with the impugned order. Whether they will be convicted or not, that is a different story. But to make out a prima facie
That you
case.
are right, that you are right. At this stage, the court will only examine one aspect of the matter.
Whether the prima facie case is made out or not.
Whether it was permissible for the trial court to take a view
Exactly.
that the materials available on record viewed from any angle is not sufficient to proceed.
Lordship.
That's the only thing we'll
That
say.
if everything is considered to be correct, true, then also no case is made out. No ingredient of these provisions of law are not made out.
Right,
Then it is a case for discharge.
absolutely.
But there is a doubt. It is not a case of two opinions.
Mhm.
Here, where is the ambiguity of the opinions? When Akhil Gogoi says, go and burn the vehicles or go and break the government. Where is the true opinion the Honorable Learned Trial Judge has found? That true opinions, I can have one opinion to discharge them. This was his view. When there is a doubt, ambiguity, it is a clear-cut, open and shut case. At this stage, that prima facie, and he himself, at one point of time, while rejecting the bail of Akhil Gogoi, said that prima facie case has been made out, which has been upheld by this honorable court. Went to the Supreme Court. Supreme Court also gave the final stamp on it, that there is sufficient material to proceed. And the division bench of this honorable court said, this is a fit case for trial. In the bail order itself, it has been indicated. And he himself, the person who wrote this, authored this judgment, which is under challenge, he himself said, I'll place all this now today. He himself found a lot of materials to make out a prima facie case. How can he change his opinion? Now I am saying he is having two opinions on a two different point of time on the same materials.
No, Mr. Saikia.
He
we
cannot
understand-
have review power.
We understand your anguish, but let us keep
Yes.
it to
Now coming next page 58.
page 58.
Okhil with Paramananda Bora. Paramananda Bora says, "Oh, Okhilda, please listen." Paramananda Bora further says, "We have planned to demonstrate together with various organizations." Coming down, Paramananda says, "Can you somehow around Golaghat at that time?" Okhil Gogoi says, "No, the problem is that I have already promised to be at Hariolai, cancelling everything. I have promised to be at Chabua because the main scenario had taken place in Sabua. The train station was burned, trains were blocked, major damage had taken place, and then the police officer was injured. One CRPF, one ITBT vehicles were burned down there in Sabua. So Okhil Gogoi himself said, I will be present in Sabua. Okhil said they are planning a big program in Sabua too. That big program turned out to be very violent. Next page, 5th line, Okhil Gogoi says, "Now my problem is I have already promised to be in Chabua during day in Panitola, at night Sabua. In the evening that incident had taken place." Again, it repeated four lines from below. Okhil Gogoi said, "I will be at Panitola during the day, during the night at Sabua. I have made the promise." Then page 60. Conversation with Pranabjyoti Handik. 4th line, "Okay, listen, do you have a committee in Sibsagar?" "Yes, our Sibsagar district committee is a strong one. Tell me what you want us to do." Okhil said, "Inform the district committee then. What are their names?" The names of the guys, Pranabjyoti, the district committee president is Jadav Gogoi, secretary is Vikas Kolita. Okhil said, "Yes, I have called Jadav a while ago. We are coming to Sibsagar tomorrow. We'll be reaching at around 11 o'clock. We, like we thousands of people, march in a procession at Dibrugarh to stop it." Then Pranab said, "Okay." Okhil said, "We are going to stop Sibsagar as well." So this is again a blockade of the place, shutting down, which comes under Terrorist Act, Section 15 of the UAP Act. Okhil says, "We are going to stop Sibsagar." He stopped Guwahati, he stopped Dibrugarh, he stopped Sabua, he stopped his place. Okhil further says, next last line, "I will reach Stansariali at around 11 o'clock. Please inform your district committee that they need to announce over mic and bring the people to shut down whole Sibsagar. It would be better if you could do it together." So he was not only commanding, he wants to be present also at the place in Sibsagar when it was closed. Next place, 4th line from below. Okhil says, "Bike rally, marching, whatever it can be done. We need to shut down the town completely tomorrow." The learned child just did not see all these things. Page 62, Okhil Gogoi with Pranab Handik further. 3rd line, Pranabjyoti Handik, "And day after tomorrow, we are announcing our program in front of Janta Bhavan." It was of date 8th December. The Janta Bhavan incident took, I think it was on 10th or 11th. "A day after tomorrow, we are announcing our program in front of Janata Bhavan. It will be a half-naked protest. The guys from all over the districts of Assam will be participating." Okhil Gogoi, "What do you mean half-naked? Make it a naked protest." Pranabjyoti Handik said, "Let's see what happens. Maybe some will be fully naked for protest. People are so angry. Please, yes, please make some people do that." Pranabjyoti Handik further said, "We will surely do something about it. So when is Narendra Modi going to reach airport?" Okhil said, "He will reach on 14. You people should be ready. All the people should be ready." Pranabjyoti Handik said, "That day we will display black flag and half naked." Okhil said, "Yeah, all right." Last line, Pranabjyoti, "Our 4 committees of Guwahati town are already alert and many people are from multiple districts are traveling by train. All right, that's all right. Then page 63. It is a conversation of Akhil Gogoi with Rahul Chetri, the middle portion. What else can you do in such a situation? Akhil said, there is no other option than to shut down Assam. Now small places are gone. Now their aim is to stop Assam. Rahul Chetri said, Akhil said, okay, so there should be a continual shutdown then. Akhil said, yes, there must be shutdown. Or Rahul says, okay, so the economical blockade has started as well. Akhil said, yes, everything have started. Rahul said, all right, let's send off. We are sitting in the university, our brains are not working. Akhil said, yes, please start it soon to stop Assam. Next page, it is regarding the train now. Akhil Gogoi with Ritumoni on 10th December 2019, middle portion. Akhil, tomorrow I am going to stay at Sibsagar town. I will reach at 11 o'clock at night. It is corroborating with the other statements also, 11 o'clock in Sibsagar. Ritumoni says, from 11 o'clock, all right, we are blocking the trains. We'll release at 4 o'clock. Akhil said, HUH, who? Ritumoni, we are blocking the Amritsar express train. We'll let it go at 4 o'clock. Akhil says, why let it go? Don't. Ritumoni says, we are blocking the way till 4 o'clock. There are some 200 people anyway. Akhil says, all right, listen, do one thing. Tell the station master that the train should be cancelled. Ritumoni says, will do. Akhil further says, got it? Do one more thing. Go to Sibsagar town and announce that I am going to reach Sibsagar tomorrow at 11 p.m. Ritumoni says, all right, it will be done. Akhil says, bring people along with you, collect from somewhere, at least 200 to 300 people. So here there's a direct instruction that go meet the station master and direct him to cancel the train. And in respect of Amritsar Express, the gentleman says, Ritumoni says, that we will release it at 4 o'clock. Akhil says, don't do it. These are part of economic blockade or sabotaging the society. Then with Sanjay Burua, page 66, 412. These are planning of various programs, Lordship. I will not trouble because the main contents are already I have covered. Now, 67. Akhil with Sanjay Da. Sanjay Da, hello. Akhil says, in Assam, Sanjay Da, in every nook and cranny, people are protesting. Lakhs and lakhs of people are in the state. The railroads are blocked. Assam is under total shutdown. There is a total hartal. Total hartal, right? Sanjay Da asks. Akhil said, yes, there is total hartal, and in every nook and cranny, the public came and shut down Assam totally. Next place, Akhil with Sunil Sonwal. Here he says about Sabwa. He is going to Sabwa. His Sabwa planning. So these are the telephonic interceptions. Now coming to the video, which were seized from various laptops as well as tablets, as well as DVDs. And from where some speeches were also recovered. So Lordship will kindly come to D44/1. D44/1. This is data records. Scrutiny report of data from Samsung tablet of Akhil Gogoi in connection with NIA case number so and so. So this is the tablet which belonged to Akhil Gogoi. Next page, folder name so and so. The data which were found out, description, part, protest against CAB led by Dhojjo Kumar, General Secretary, KMSS. Pamphlet of KMSS called public to join the mass protest against citizenship bill. to be organized from 11 hours to 13 hours at Dispur last gate. Fire-led marshal, then CAB protest rally addressed by accused Akhil Gogoi, advisor KMSS. Then road blockade protesters, rail roko program, CAB protest rally. All these records are part in his hard disk of his tablet. Then the photographs also, next page. All these pages of photographs. A1's photographs is clearly visible. He is standing in front of train 9. Lordship will kindly see. There's a train. All the persons are sitting on the railway track. And A1 is standing in front of the train. Other photographs are also there. Then 10, he is addressing the gathering there. Page 12, translated version of accused Akhil Gogoi's speech, source retrieved from Akhil Gogoi's tablet. Page 13, second paragraph, last line. This way, every Assamese person need to come out in highway tomorrow morning at 6 o'clock. By coming out in highway, they need to disrupt and disconnect all means of communications. We need to come out peaceful and democratic way and shut down all central and state government offices by picketing. We need to shut down all railroads, compel to stop all rail services. We need to shut down all national highways completely. We need to stop the administration system of Assam completely. Then only central government will be afraid to implement CAB or withdraw the CAB, which is going to implement. At this movement, I want to make one call to Assamese people. Treat tomorrow a day like Assam one. What happens today, in which way people come out in highway? I was in Dibrugarh today till 9:30 hours. And I was with people and saw that in front of each and every house, people burn one tire on highway in front of their houses and tell that I will not allow to pass any vehicle in front of my house. That means each and every household observed the burn today. Thousands and thousands of people of Dibrugarh came out. People are from each family came out and tells in every clear word that we do not accept CAB, and as long as CAB is not withdrawn, we will not spare anybody. At this moment, before shut down the internet service, I want to tell you through Facebook that people, tomorrow is one very important historic day. Tomorrow will not sit in our home. Tomorrow, all of you come out highway and stop all communications in highway. Tomorrow you will sit down in the railroad and disrupt the rail service and tell central government that we cannot accept the CAB. All the offices near to your home, near to your town, from Panchayat office to DC office, all offices of central government or radio center, Doordarshan Kendra airport, you will go there and make all paralyzed. Tomorrow will be very much important for the day for Assamese people. Tomorrow there will be new history written for Assam, so that central government can not write new history and pass the CAB bill, which can destroy Assamese community. From that, Assamese community need to demonstrate its valor and power today, in Guwahati, in Dibrugarh and all over Assam, in which way you come out in highway in mass and paralyze the whole system the same way. Tomorrow at 6 o'clock in the morning, you come out in highway. Observe the protest fully and tell central government that Assam will never accept CAB, will not accept CAB, will not accept CAB, Joya from etc. Then page D47/1, scrutiny of videos seized from Tulumani Dwara SI. So here also one video which was recorded where he mentioned page, it will be 2, last 4 lines. Therefore, from this platform, I call everybody to be unified. ASU, KMSS, AJYCP, all nationalist organizations of Assam, leftist organizations of Assam, and all political unified, etc. So that CPI ML party is always playing there. Now coming further, another speech. D 56/1. Translated version of from Assamese to English of speech delivered by accused Akhil Gogoi. Source YouTube Assam Diary Channel. Here I am reading from the bottom part. This is my first request. About 12 lines from below. This is my first request. My second request is that meanwhile, police, army, CRPA are called. My revolutionary colleagues, those who want to work in this movement with more dedication, feel that they want to carry this movement for long, as per requirement. For sometimes they go inside the village, organize the village people, organize the people from tea garden, organize the people from interior area. The movement will continue in town, but with the people from village block the highway. If there would be 20 check gates like this in Tiok area, how many places police will go? Get my point. But in case of Jorhat, they will deploy 2,000 police and controllers. At present, you know how many PS are there in Jorhat. Even though it can be possible to control us here, I'm skipping all this. And next page, last 4 lines. Now, how I will tell what mass revolution is. We will aware the mass and stop the transportation of economic and natural resources from here, like transportation of crude oil, coal, tea, limestone, etc. I want to tell the important thing. This is what he is preaching. Last 4 lines. Now, how I will tell what mass revolution is. That means mass revolution is that will make aware the people, we will aware the mass and stop the transportation of economic and natural resources from here, like transportation of crude oil, coal, tea, limestone, etc. I want to tell the important thing. These are part of his speeches. And there are videos also, Lordship will kindly come. Lot of pages are there. These are all part of the technical evidences. And these are recovered from his not mobile, Lordship, the tablets and the other laptops which were seized. So these are the basic documents which
Take this.
the charge sheet contained. So whether from this document, whether there can be any doubt that there no prima facie case is made out, that Lordship will have to see. Whether there is ambiguity, there can be 2 opinions of these statements, of these evidences, which are scientific evidence, Lordship. And whether they are fit for to be trial or they can be put in brush aside and stop the whole process. The statements which I read out yesterday very clearly says what is what, and some of the statements were coming from his comrades because he always addressed his colleagues as comrades. So if his own people, the vice president or the president or the working president of KMSS are saying all those, giving all those statements. It is nobody's case that these statements were recorded upon coercion or upon fear. It is not like that. Otherwise, human rights, they are all free. They could have registered case in the Human Rights Commission. Nothing of that sort is forthcoming. So now, these are the materials upon which the prosecution laid their case for trial. Before I place the relevant case laws, I would like to place the other part, how the case was suddenly stopped by the learned trial judge at 2 o'clock.
We'll do it at 2.
Yes,
So now you have 3 parts.
Lordship.
You would like to address the court on your basic grievance that
Yes.
it was abruptly
Closed.
Stop. So to that extent, you say that the NIA was not given an opportunity to properly respond. Second part is the observations made by the trial court,
Yes.
reaching the conclusion. and third is the case law.
case law.
So approximately how much time will you take?
15. By 3 o'clock, I will close.
And what about your side? Will you,
We'll start today.
will start today? Okay. Mr. Chaudhary, you
Yes.
wanted to do it on 9th,
No,
but
no, I'll
we
do it
thought
to-
if possible,
No, no, I'll do it today.
if it is.
So in
okay
fact, your lordship's request was conveyed to me.
it was
I
a
put in
request.
some extra effort and we have done
It
it.
was a request.
Ah.
Well, what happens is if we allow other matters to come in as
In
part of
between.
it becomes a little,
Even I also thought, my lord, why not, might as well
and
close.
then this is not a regular bench.
Right.
Bench has to be constituted.
It's okay. I've come prepared.
Lordship, I have missed two important documents from my documents.
Mhm.
One is D63.
D63.
D63,
D63.
yes.
This is the detailed damage caused to government and private properties during the protest against CAB occurred in the district is enclosed. Separate cost estimate pertaining to damage to government private organizations are prepared helping you in the investigation. So the deputy commissioner Dibrugarh has given it to the IO. And the list lordship will kindly see next page. Details of undemocratic public agitation, mob violence and arson. In Moran, the photographs, the government office was partially damaged, right hand side. Gaon Panchayat office is damaged. Then next page, Huang railway station, all the glasses were broken and there was the arson. Third photo. Waiting room of the railway station is partially burnt and window glasses, etc. were broken by the miscreants. Then right hand side, office of the Chabua revenue circle, how it was damaged. Next page, Sabua railway station, fully damaged. Lordship may kindly see how the death. Then the post office, left hand side. ASCC counter Sabua broken. Municipal board Sabua completely demolished. Rohmoya Gaon Panchayat broken. UBI Sabua branch, Lordship, you can see what is the fate of this bank. Identically, all these photographs are carrying identical photographs, see, everywhere. House of the Honorable Chief Minister, then Chief Minister's house is also broken, that is also given, page 15. The Chief Minister's house is attacked. So this is one part I missed out, and the other part is Lordship, page 60 D69. That is the conversation of the other accused, Bittu Sonwal. And 71 is Bittu Sonwal with Hujjokor, both are accused. Then 74 Bittu Sonwal with Jojo, and 78 Bittu Sonwal with unknown person. So all the accused, their telephonic conversation were intercepted. And those are part of the record. And these are the damaged property list, along with photographs. Yeah, now,
Yes, very-
Before going to the judgments, I would like to place this honorable court, paragraph 16 of my memo of appeal. First, let paragraph 17, Lordship. Then I'll come to paragraph 16. The development of 30th June 2021.
Just a minute.
Lordship. Internal page will be 19.
Yes, please.
Yes, paragraph 16, I'd like to read out, Lordship. The facts will be very clear then. On 36/2021, on behalf of NIA, so and so appeared before the learned judge, special court NIA, and made a prayer for 10 days adjournment of the case on the following two grounds. While later dated 29/6/2021, he received a communication at 7 p.m. on the same day that he was engaged by NIA to appear on their behalf on charge hearing. He was yet to completely read the documents, and the briefing of the case could not be completed at such short notice. It was not possible for him to argue and counter the arguments submitted on behalf of the defense, which was submitted the written arguments consisting of 1225 pages. He pointed out two applications filed on 28/6/2021 and 29/6/2021 by NIA. First one is an application under section 17 of the NIA Act, filed for appropriate order for keeping the identity of protected witness C as secret. B, an additional charge sheet under section 173(8) of the CRPC was filed on 29/6/2021, and the fate of the same on its admissibility was not known, as the prosecution did not receive any order till that moment, that is till 11 a.m. on 30th June. These two applications were filed, one on 28th and the other one on 29th. Now, during the deliberation for the prayers for adjournment on behalf of NIA by the senior counsel of NIA, he had come to know from the submission of the learned counsel for the defense, Sri S. Borthakur, that they had filed an objection to the additional search sheet filed on 29/6/2021. So they filed an objection on the previous dates. Upon such submission on behalf of NIA, it was prayed that a date may be fixed for hearing on the issue of admission or acceptance of the additional search sheet on 29/6/2021. So we filed the second application with the additional search sheet. According to them, they have filed an objection on 29. We do not know, and no order was passed. So they are required, say, hearing. And we have not received a copy of the objection till 1st of July, right? 30th evening, we received a copy. It is also reiterated that
Who is the judge, near special judge?
I do not want to take any name.
All right, that's all right.
It is in the record.
Das. Das. Pranjal.
All right. All right, please proceed.
Because I am not on personal, that's why I do not want to take
No,
name.
that's all right.
Because I have to say certain things here.
Mm.
It is also reiterated till that moment, the Honorable Court also disclosed that it had not passed any order on such application. It was told to us that I have not passed any order. Even it was video recorded. If Lordship wants to see that record also, because I was doing the case from my home. It was during COVID time, COVID-2. So the Honorable Court said that till that moment, the Honorable Court also disclosed that it had not passed any order on such application, as well as on the acceptability of the additional charge sheet. However, in most shocking and astonishing to find the order passed on 29/6, where the adjournment prayer was rejected. Later on, we have come to know, and we obtained the certified copies later. During the course of hearing on adjournment on the prayer made by the senior counsel of NIA, the defense counsel fairly submitted that before the court that he cannot object for adjournment on the ground of projected by NIA. However, the adjournment should not be for 10 days, but maybe for a shorter duration. The NIA counsel immediately reduced his prayer for adjournment from 10 days to 7 days and prayed that the Honorable Court may fix the matter on 7th July 2021 or any other day thereafter. The whole deliberation came to a conclusion as the learned special judge asked the learned senior counsel of NIA to send any officer or his colleagues advocate in the afternoon to check the notified next date, as he would fix the date after checking the ongoing hearings in 3 other matters pending before the trial court. It is once more respectfully stated that in the afternoon, the prosecution had come to know about the impugn order dated 30/6/2021, by which the learned special judge NIA rejected the prayer for adjournment. It is further stated that in the same impugn order, it did not mention on what ground the adjournment was sought, and very mechanically the learned special judge NIA rejected the prayer on which the adjournment was sought by merely rejecting the prayer solely on the basis that the charge hearing was commenced in the month of March 2021. So this was the ground. I'll come to that. It is respectfully submitted that till that time adjournment prayer was made on 30/6/2021. The outcome of the two applications filed on 28/6 and 29/6 was not known, and the Honorable Learned Single Judge himself disclosed during the deliberation that he would pass orders on those applications, but which is most important and what is most important is that till that moment, no orders were passed, although the certified copy shows a different story. These are the things very clearly. We have also 25 years of practice. When the Honorable Court says certain things, we believe it. Later on, we found that on 28th order was passed, on 29th order was passed. This is the happening. This is the ground reality, Lordship. So if Lordship is pleased to look at those certified copies, we have annexer I, J, K at page I is 332. So here date is 28/6/2021, page 332. This is the order. So he allowed our petition that the secrecy will be maintained under section 17. And on 29, peruse the petition supplementary search sheet dated along with his annexer heard the prosecution. The prayer is allowed. The supplementary search sheet dated 29/6/2021 along with his annexer is accepted into the case record. Copies thereof shall be furnished to the defense. So we have to submit the additional search sheet to the other side. Petition number 195/2021 stands disposal of the said seal materials. Object 13. We
You're
kept
reading
in
from page number?
page number 334, 333 and 334. These orders were passed subsequently, Lordship. It was not passed on those dates. With a back date.
All right, yes.
And thereafter the on 30, the adjournment, this case, this adjournment petition application was disposed of. That is at page 335. Lordship may kindly see. In these cases, the first part, second part shows who will appear. Now, page 336, the case is presently at the stage of search hearing, wherein the defense concluded on 24/6/2021, where after it was fixed today, that is 30/6/2021, on the prayer of the prosecution for brief reply to prosecution argument. Further submitted that Learned Advocate General Assam would appear on behalf of the prosecution. In the meantime, a supplementary search sheet was filed on 29/6/2021, containing statement of one protected witness recorded on 27/6/2021 and 3 photos along with his memo on the same date. The copies of the same had been furnished to the defense. The defense has filed an objection to the supplementary search sheet. At what time they received the copy, what objection they filed, we do not know. When we filed it on 29, nobody was there for this. Accordingly, today, this cycle Learned so-and-so has appeared on behalf of the NIA. In this case, prosecution has argued on the case regarding charge over a period of almost 3 months. Thereafter, the defense completed the arguments. Considering the long period of time for which the matter has been pending at the stage of charge hearing, the Learned Advocate General, Assam representing the prosecution and Sri Borthakur Learned Defense Council were requested to submit and complete their reply and arguments, if any, on the additional materials comprising just one relevant photo and statement today itself. This is a completely false statement recorded by the learned judge. Whole deliberation was regarding adjournment. This is from where he has written it. It is to his knowledge. If he had said that I am not allowing it, start your arguments, just like my learned senior friend is doing today, I would have started. If the court wants to hear, we will leave all the grounds of adjournment from our side. We always forthcome. So this is a completely incorrect statement recorded by the learned judge. So that the order on the point of charge can be passed expeditiously without further delay, as the same has been pending for long and one accused is an UTP, and if charge is framed, trial can commence without further delay. Moreover, long pendency of this case at the stage of charge hearing has delayed pending charge hearing in 4 other matters in which the accused persons are in custody. I have already submitted the 3 other cases hearing was going on. Therefore, he wants to fix a fresh date. This is telling with that. The learned defense counsel submitted that they just support written objection filed by them. On the other hand, this objection copy was not served to us till that moment. On the other hand, the prosecution sought an adjournment seeking 10 days time. The court considers the said prayer as not justified in the backdrop of the aforesaid facts and circumstances. In this case, the NIA and the prosecution have availed sufficient time for investigation and charge hearing respectively. The prosecution conducted the charge hearing over the period from 16/3/2021 to 10/6/2021. The defense argued from 22/6/2021 to 24/6/2021. It may be mentioned herein that the charge sheet was filed on 29/5/2020 itself. Therefore, the court is not willing to countenance any further delay on the part of the prosecution. Pausing here for a moment, Lordship. The learned trial just said that we have started the charge hearing on 16th March 2021 and it was completed on 10/6/2021. Less than 3 months. That was the peak of COVID time. My learned friend was appearing not more than 6 to 7 times, half an hour time at the fag-in. He was submitting. So if we 6 days, if we take half an hour, that means 3 hours he submitted. So he submitted 3 hours only placing the records, whichever is relevant. They were given time from 26/6/2021 to 24. That means 3 full days they argued. The other side, if I am wrong, my friend can immediately say no. They completed 3 days hearing from 22nd June to 24th June, 22nd, 23rd, 24th. From 10:30 till afternoon, every day. So we took hardly 3 hours during this 3 months time. It was in peak of the COVID-2 situation. Now, Lordship will kindly see the date when our present hearing started. Our present hearing started on 22nd of February this year. On 1st of April, I have the order copies. The other side had already completed their arguments. I'll place that order. In this case, instant case, on 21/2/2022, Lordship will see, taking note of the request made by the respondent counsel and appreciating the urgency expressed by D. Saikia, we direct the registry to list the matter on 24/2/2022 for hearing as fixed item. This case order. So on 24/2, L. Devi and PRD, so and so on joint pairs, this matters on 4/4/2022. Then on 1st April 2022, our D. Saikia, so and so, this Saikia has addressed elaborate arguments from my side, assailing the validity of the impugn order dated 1/7/2021 passed by the learned NIA court, discharging the respondent accused. Sensua submits that his senior K. Chaudhary, learned senior counsel, will argue the matter on behalf of the respondent, but he is presently out of station. As such, a prayer has been made to adjourn these matters for a week. Taking note of the request made by the respondent counsel and keeping in view of the ensuing Bihu vacation, we direct the registry to list these matters again on 19/4/2022 as fixed per third matter. On 19/4, D. Saikia, so and so is present on behalf of appellant K. N. Chaudhary, representing the respondent, seeks adjournment of these hearings today by citing personal difficulty with a further request to post the matter on 28/4. On 28/4, so and so arguments remain inconclusive. On request of the parties, let the cases be listed again on 17/5. On 26/17, I do not have that order. I think it did not pick up. It was not listed. On 26/2022, heard D. Saikia, Satyanarayan assisting, We have also heard K. N. Chote, learned senior counsel, SEZ by S. Borthakur, representing a respondent, who have concluded his arguments. So my learned friend has already concluded his argument on 20th of June. Now, the other day, they wanted to give a reply. Did I object? I did not object. He has concluded his argument already. In this case, in June itself, and we want a fair hearing. Today, he will argue the whole case afresh. I will have no objection. So when our team completed the arguments on 10th of June, and they argued for 3 long days, at the end of the arguments, they submitted 1225 pages written argument. Last moment I was engaged on 29th, on 30th, I made a genuine prayer. Kindly give me some time to prepare and go through the papers. The learned judge also agreed that there is some urgency. What is the urgency? They were not showing urgency. What is the urgency of the learned judge? He knows. The other side said that I cannot object to the grounds, but don't give a long adjournment. So it was a fair thing on their part. And we have also reciprocated that instead of 10 days, give us 7 days time. And he said that 7 days time, I will give a date because I have 3 other part matters. I will accordingly give a date. At that moment, he passed all these orders, 28th order, 29th order, and 30th order. And next morning at 10:30, it was fixed for passing of the order of the whole charge hearing. We did not respond. Whatever there was in 1225 pages written arguments, whatever was argued for 22nd till 24th. We have to counter now whatever I will be arguing, because I started on the first day. Midway Lordship allowed them to complete the hearing. Then it is my turn. They concluded on 28th of June. My turn in that time, Lordship, that Supreme Court judgment came again and IA came up. Here also an IA came up. 2 IAs came up. Here the IA is regarding section 124A of the IPC. There the additional search sheet was the IA's material, subject matter. So what is the urgency of the learned single trial judge? To abruptly close the whole proceeding. The defense counsel was not saying that my client is languishing in the jail. That is not the recorded statement here. His only ground is that the hearing started in March. Now our hearing started in February. Nobody is complaining we are 1 year ahead now. Because whatever time Lordship is taking, it is for an effective hearing. Nobody is dilly-dallying. We are not dilly-dallying, neither they are dilly-dallying. We have to look at the convenience of the Honorable Court. We have to look at the availability of the materials and the times of the counsels also. So in that situation, at 10:30 next day, it was fixed and all were discharged. Without touching the vital definition of what is a terrorist gang. So I'll come to the merit of the order also a little bit later. Now, here from 28th June, again, the case was going on. Till today, it is going on. Nobody is doubting any unfair play here. So people have expectation from the court. Forget about the outcome. And when that statement was made by the learned judge there, all the officials were sitting in my chamber. It was on this kind of system. Yeah, it was on this video conferencing. Everybody was hearing that at 5:30 our officer have to go there and take a date. And when they went, it was said that this adjournment prayer is rejected. Tomorrow 10:30, the case is fixed for final order. It is difficult for the lawyers. It could have been happening to them also. People must have trust on the institution. And when an honorable judge sits on that chair, he speaks something, everybody believes. So that is the problem, Lordship, where the procedural lapse is there, the violation of the natural justice has been flouted, principle of natural justice. So finally, last paragraph, accordingly, I am of the considered view, in the interest of justice, page 338.
Yes.
there should be no further delay whatsoever. What does he mean by that? I do not know. There should be no further delay whatsoever on the part of the prosecution, and hence the prayer of the prosecution for adjournment is required to be rejected, and the instant matter should not be kept pending at the stage of charge hearing any longer. The prosecution prayer stands rejected, fixed 1:10, that is next day at 10:30 for orders on the point of charge. And all the accused persons were brought to the court and they were discharged and they were released. Next page, that is the order. Accused Akhil Gogoi shall be produced before this court physically on the next date for pronouncement of the order on the point of charge. Inform accordingly. All the remaining 3 accused persons shall also be physically present before the court on the next date. So everybody could guess what is going on here. So on this point, my ground, I have specific ground on this point. How it was a procedure, if Lordship is pleased to come to page 27, ground number H. H and I am referring. For that the learned judge, Special Court NIA, has miserably and grossly failed to appreciate the fact that in paragraph 8 of the impugned order dated 36/2021, it has been stated that the learned defense counsel support written objection filed by them. In the morning hours during the deliberation, the defense counsel did not mention about any written objection to the prayer of the adjournment. During the deliberation also, the other side's lawyer did not say that we filed objection. That is where I doubt something is really not clean. Otherwise, during the deliberation, somebody would have said that we have filed a written objection. Then immediately I get an opportunity to give me a copy. From where that written arguments evolved.
Written argument was filed actually.
Written objection was filed later on in the afternoon, on 1st, we received it, on 1st, after the order was passed.
Not written arguments.
Written objection.
Written
From
objection.
where it was submitted.
Objection to what?
Objection to the supplementary search that they have filed.
On 29th, the previous day. We are entitled for a copy, and there should be a hearing on that. Simply allowing our prayer without hearing is also not the procedure.
Their prayer has been allowed.
They could have come to the court. Suppose it was not allowed. We would have come, it was allowed. Suppose their charge framing was rejected and charge was framed. They would have come to the court on the same ground that we have filed a written objection, but it was never heard. So something is not meeting the eyes here. We have to read between the lines. If written arguments is
But
filed
are
after
you-
closing,
Are you alleging malafide on the judge?
if Lordship can take that also, because I do not have proof, but the surrounding circumstances, the Supreme Court, my learned friend always says that we have to read the overall situation.
My lord, I have a
On
perspective.
a different-
No, I have
Not
a
on this ground.
No, I have a small perspective in this matter, my lord.
Mhm.
The way my lord, the judge is being attacked,
Yes.
and in his absence, he is defenseless. My lord. Who will defend?
We cannot make him party.
No. Then
We cannot make him
Then
party.
my lord, there are.
I have full instructions to attack.
No. I have, my lord, there are ways and means of dealing with an issue. But this naked and brazen attack on a judge who is not, who will defend him, my lord? Therefore, my lord, these are matters Lordship will take note of. The judge is not before Lordship to defend what he did. Of course, I was not present, my lord, before the proceedings.
No,
in-
anyways,
The
I
facts are
think
speaking.
yesterday
The
we
facts
have,
are speaking.
we
End
have
of the day,
indicated.
Lordship is testing the order.
We will see the correctness in the procedure.
Yes.
But, Mr. Saikia, if you tone your arguments to point it, then I think he will have to be implemented as a.
No, I am on the facts. I am not on personal thing. That's why I did not utter his name also. I know his
No,
name.
but
I am not uttering his.
That's all right. We didn't find, we wanted to just see because we
Yes,
know.
whatever I am saying,
Mhm.
whatever I am saying, it are all based on facts, hard facts.
But
The
that's all right.
application, application of 28, these are part of the records, Lordship
what-
can say it.
What we will request is that we understand your anguish or your client.
My anguish is not against me. My anguish is that my clients
Hmm.
will stop trusting the institution. That is where what is troubling me.
No, that's correct, but then please tell us one thing. If you make these submissions, then you will expect the court to deal with it, no? How
That
do
is
we
why the
deal
ground
with-
I have taken. I leave it to your Lordship.
How do we deal with these submissions?
Lordship, we always suppose a learned single judge gives an order, we challenge it to the division bench, or the division bench order is challenged in the Supreme Court. We say certain things, but if the judge is not to be a party. These are procedural lapse, violation of natural justice, which I am urging.
No, it's
But
fair enough.
why, yes, now Lordship can see, what is the urgency of the honorable judge to fix the matter within 12 hours? Or maybe 17 hours.
So therefore, your argument is that this whole thing was done in hot haste.
Hot haste, but I do not
And,
give, I am not attributing any motive there.
Any motive?
I am not
That's
attributing
all
any
right.
motive.
Then it's fine.
I am not attributing any motive.
Then it is fine.
That is why the facts are such as Lordship will have to see what are the hard facts.
No, then it is okay.
Then
If no motive is.
Otherwise, I'm not bothered who is X, Y, Z there. I am saying the institution, not the particular person there. Today, Lordship is sitting here. So everybody has to have trust in this institution.
No, that is fair enough.
One point, Your Lordship, with permissions from the Honorable Court, I am. So far as.
Everybody is permitted to make every submission before this court. Don't have to ask. If you don't speak, how will you know what is happening?
Lordship, now
Tell us
Your-
what
Your
is- what
Lordship,
is it?
kindly note one thing, Your Lordship.
Can you come a little closer?
The Advocate General is submitting, Your Lordship, that for 3 months, they're only for 3 hours, they have been submitting for half an hour.
These things you
These are
reply.
these are the kind, this is the statement made, Your Lordship, but the thing is, Your Lordship, these are not brought on record by way of in the pleading.
So you
that's
make
the-
your reply when you
Lordship,
argue. Why are you
That's just I
interjecting
am
now?
pointing out. Your Lordship.
No, you make a note.
Lordship.
And
These
meet all
records
the-
are before this honorable, how many days the orders were?
Lordship, that is there, but
It
the-
is part of the record.
nobody.
He is entitled to make his
Lordship,
argument.
that's, I am
You
not
are
saying that.
entitled to make your
Lordship.
reply.
And I am making that submission from his observation that 10th of May, March, he started the argument from his
We'll
record.
hear your
Lord,
version,
Lord.
but the only thing is we were wondering whether there is any malafiding in.
No. I am not
Unless
the
it has
institution.
gone from his mouth
And
that
in that
no
case,
motive is.
See, every
appreciated.
argument made in the bar has to be taken seriously by the court. We can't deal with these arguments.
Lord.
That is the reason. That is the reason we
Lord.
asked him. He clarified that there is no motive in.
Personal, no.
There is no personal motive.
I am saying the court.
We'll record it in the order. No
Lord.
personal motive.
No personal motive.
Whatever be the outcome.
No.
Once Mr. Saikia has clarified, then it's fine.
Lord.
Reading further. If written objection is filed after the closing of the hearing, the prosecution is entitled to a copy of such objection. In fact, during the course of the hearing of the adjournment prayer, the learned defense counsel agreed for the adjournment, but he had prayed that the honorable court may fix a short date, not 10 days adjournment as prayed by the prosecution. The defense counsel also stated that once the prosecution completes his argument on the charge hearing, he would respond to the same in another 5 to 10 minutes. This was also said by them. Once we finish, they will take another 5 to 10 minutes to complete the hearing. Therefore, the learned trial judge has abruptly closed the search hearing by denying the prosecution to complete their arguments, which is nothing but denial of effective hearing and violation of the principle of natural justice. The learned special judge court has not appreciated the fact that the hearing of framing of charge remained inconclusive, and by the impugn order dated 30/6/2021, thereby the learned special NIA court not only rejected the prayer for adjournment, but also abruptly closed the hearing on the charge and fixed 1/10/17/2021 at 10:30 for orders on point of charge. Thus, the said impugned order caused grave prejudice to the investigation agency, and there has been blatant violation of the principles of natural justice as well as the principle of procedural law. In that view of the matter, the impugned judgment is liable to be interfered with, and the case may be remanded back to the learned special judge NIA court for further hearing on charge. We are not praying for change of the court, Lordship. we want the matter should go to the same court. If we had any personal motive or personal malice, we would have said that we are
Fair
different
enough,
court.
you have clarified it.
Yes, Lordship.
Okay.
So now coming to the merit. The materials which I have placed this morning, Lordship, and yesterday also, the same judge, paragraph 16,
Paragraph 16 at page.
page 17.
Yes.
The respondent accused one had filed a bail application before the learned judge NIA Guwahati, wherein the learned judge special NIA court has dismissed the bail application with the observation that upon perusing, considering and analyzing the entire materials available on record in the case diary and the charge sheet dated 29/5/2020, as narrated and discussed, more specifically the material discussed in paragraph 56, 1 to 9 above, I have to the considered finding and opinion that it cannot be said that there are no reasonable grounds for believing prima facie that the accusation against accused Akhil Gogoi are true, vis-a-vis section 18 and 39 of the UAPA Act. Further, on the basis of this material, I am of the considered view that it cannot be said that the accusation against JA1 are wholly improbable. Consequently, the bail application of accused Akhil Gogoi stands rejected at this stage. Further, the respondent accused Akhil Gogoi had challenged the order of the learned special NIA court before the Honorable Guwahati High Court in criminal case 186 of 2020, wherein the Honorable Guwahati High Court had affirmed the said order as there are sufficient materials in the charge sheet against the appellant. As such, the court does not find any infirmity in the findings returned by the learned special judge that there are reasonable grounds for believing that the accusation of commission of offences punishable under chapter 4 and 6 of the UAPA Act against the appellant is prima facie true. Hence, the instant appeal being devoid of any merit, the same is dismissed. Furthermore, the respondent accused Akhil Gogoi approached the Honorable Supreme Court by through SLP so-and-so challenging the order of Guwahati High Court, wherein the Honorable Supreme Court, after carefully perusing the materials on record, dismissed the SLP of the same. So these three judgments, I have placed at page 332. Of course. I'm sorry, not the judgment bill ka judgment. Bail or judgment. 268. 268 starts, Lordship. On 7/8/2020. In fact, I argued the case on behalf of NIA at that point of time in this case. So 268, Miss Case NIA 18 of 2020, the same learned judge considered the bail application and relevant paragraph 311 page number.
There was one matter where it came up before this court. I had authored a judgment.
Yes.
That's different.
That is another case.
That is in respect of Sabua.
Okay.
Same material, only thing is, my lord, protector's witness number A and B is here, and otherwise it's more or less the same material. That is
So,
reported.
Yeah, one case is Chanmari
Now it is summary.
and the other one was
Sabua.
So in one case, the judge did not grant bail. This order was upheld by the High Court
Yes.
and it went to Supreme Court. There also it was maintained.
Yes.
In the other matter, the bail was granted.
Yes.
This court also.
Against that, appeal was preferred, appeal was dismissed by.
And then was there any further? appeal?
No.
No, that was not tested.
Okay, so in one case, there was bail granted, in the other was not granted.
Yes.
Okay, so we are in this case, we are connected with the matter where bail was not granted.
Not granted.
So 311. Para 57. whatever materials we have, he has recorded everything in the order, very long judgment. Para 57. Upon perusing, considering and analyzing the entire materials available on record in the case diary and charge sheet dated 29/5/2020, as narrated and discussed, more specifically the materials at para 56, 1 to 9 above, I come to the considered finding and opinion that it cannot be said that there are no unreasonable grounds believing prima facie that the accusation against accused A1 are true vis-a-vis section 18 and 19 of the UAPA. Further, on the basis of these materials, I have the considered view that it cannot be said that the accusation against A1 are wholly improbable. This is in keeping with the test enunciated by the Honorable Guwahati High Court in the case of Jayanto Ghosh. Upon such an opinion having reached and statutory bar of section 43D5 proviso come into play, the special court is prohibited from granting bail to the accused Akhil Gogoi, irrespective of merit or otherwise of the other aspects of its bail application. Consequently, the bail application of the accused Akhil Gogoi stands rejected at this stage. Same materials considered by this honorable court, paragraph 24, page 337. This is the division bench of my Lord Justice Surana and my Lord Justice Ujit Borha Court. It starts from 313, paragraph 24.
Yes, so order has been affirmed.
Affirmed, Lordship, I would like to place these two paragraphs because here the honorable court said this case is fit for trial also.
Where is it?
Paragraph 24. Based on the materials available on record, the court is unable to hold that the violent protest of the state did not or could not have had any terrorizing effect on the harmony of the innocent public at large. Rather, the court is of the considered opinion that on being provoked by the appellant, as the violent protest by burning of tires caused rail, highway, and internal road blockade, the same is sufficient to give rise to a critical law and order situation that as a whole had threatened the security of the state. The act of violent protest were aimed to strike terror in all sections of the people in India, irrespective of caste, creed, religion. Moreover, by burning of inflammable substances, the supplies essential for life of community in the country was disrupted. By use of violence, the appellant-led mob had brushed aside the noble concept of non-violent protest, which is popularly known as satyagraha, and such conduct of paralyzing the government machinery, causing economic blockade, causing enmity between groups, disruption of public peace, and widespread disharmony and dissatisfaction toward the government acts are prejudicial to national integration and as such squarely falls within the definition of terrorist act defined in section 15 of the UAPA. The court is also unable to accept the submission made by the learned senior counsel for the appellant that strike calls and speeches made by the appellant falls within the freedom of speech and expression as guaranteed under part 3 of the Constitution. Because of the fact that the call transcripts, which I have placed today, which are accompanying the charge, it clearly indicate that the appellant wanted to protest in such a manner which would disrupt all modes of rail and road transport and to paralyze government machinery not only on the other dates, but specifically on the dates when the Japan Prime Minister had slated to visit the state. It was submitted that although there are rail blockade, but there are also evidence to the effect that railway administration had themselves suspended the rail traffic, but the court cannot find fault of the such action of the railways because by such action, they had secured the lives of a large number of rail users and saved the trains and other railway property from being damaged by the violent protesters, which reportedly burned down Sabwa rail station. In the light of the herein above referred materials available on record and having regard to the requirement of 43D5 of the UAPA, court is unable to record its satisfaction that the materials brought on record in all probability may not lead to conviction. Materials on record disclose culpability of the appellant and his involvement in the commission of the alleged offense as more fully mentioned in the charge sheet. It may be mentioned that the court is conscious of the fact that the duty of the court at this stage is not to weigh the evidence meticulously, but to arrive at a finding on the basis of broad probabilities. Having regard to the requirement of section 41D5, the court has made a deep probe into the matter so as to enable prima facie arrive at a finding that the materials
Yes,
collected.
but Mr. Saikat, these observations are not to have any bearing in trial. So
Yes.
we'll leave it out for now.
This will not have, but what my humble submission is that when this kind of final, here there is a direct line also for trial. Last line. Last line. Therefore, we further make it clear that the issue of admissibility and credibility of the materials evidence presented by the investigator would be matter of trial. So when this kind of observation is already there from a higher court, prima facie, he has to be satisfied. And we have to make out a case prima facie. It should be giving a prima facie color to the allegations. These materials may not be finally considered for conviction. There are two different stages.
No, that's right, Mr. Sankya. We have seen, you have drawn our attention to whatever was
Lordship.
there in the statute, and we'll examine it and we'll
Yes.
of course, hear their arguments and then take a decision.
One final lordship.
But just on an academic note,
Lordship. The Supreme Court also has said the same thing. We have seen the materials and it is not a fit case for interference. Seen the materials, that word is also there.
no, that's correct, but on an academic note,
Lordship.
what we are putting it to you is that that process was pertaining to the question of grant of bail,
Lordship.
right? It's no doubt correct that the materials were the same
Same.
as it was then, as it is for framing of charge,
Additional, the third additional search sheet and the
Search sheet.
photographs.
correct,
And
But-
and one more witness,
Correct.
witness C.
correct. But what we are posing to you is, in all these proceedings, grant of bail, this is not about this outcome of this case, that we'll see. Framing of charge, issuance of summons, these are various stages, and then finally either conviction or acquittal, whatever. The approach of the court is very, very different. Well, granting bail, and particularly in UAP, this is on an academic note.
Lordship.
Don't take it that it's a
Lordship.
commentary on
Mm.
this matter, this way or that way. The court has to see, subject to 43D subsection 5, whether the materials are such that it requires a custodial interrogation. That is the parameter. And if granted bail, whether the accused is likely to jump the law. These are the two parameters. When charge sheet is filed for issuance of summons, the law is well settled that the court has to see whether there are reasonable grounds to proceed. And that is a very soft finding. Unless it is absurd that the charge sheet contains materials which are absolutely no chance of leading to conviction, the trial court is expected to issue summons. Once the party appears, then the question of framing of charge, which is the case here. Here, primarily the court has to see if the materials are taken on the face value. Then there is a strong possibility of conviction or even a probability of conviction. If the court is of the view that the materials taken on face value, viewed from any angle, cannot lead to conviction, it is a case of discharge. That law is settled since Praful Samal.
Yes.
Since that time, that law is settled.
There are earlier.
There are other decisions. also.
1979 judgment is.
So what we are putting it to you that the observation made by the division bench, whether in this case or that case, granting bail or not granting bail, in any case, would not have any bearing in the subsequent proceedings. That's what we are trying to make.
That is correct, but we have to see it from a different perspective. What is the basic thing? Section 43D says if prima facie case is against the person, then bail should not be granted. Prima facie. Here also, if a prima facie case is made against the accused, then it is a fit case for trial. That is, I'll place the judgment now. Here also, there is no fundamental difference. Prima facie, the court has to
That
get
you're right.
satisfaction.
Only difference is those judgments are rendered in
Bail cases,
IPC sections.
IPC, but 43D is different. 43D
Here-
specifically prima facie is there.
So the considerations may undergo substantial change because of 43D.
Yeah, exactly. It's more stringent now.
Because in all those cases, some
IPC cases have different footing, but 43D, may I just place this as order? This
43D is almost kind of a reverse.
exactly, Lord sir. It's like in this 43D, 43D होना, IP, उसको, UAP, छोटा वाला box. That word is there, prima facie. (43) says modified application of certain provisions of the code. Here D5 says, notwithstanding containing anything contained in the code, no person accused of an offense punishable under chapter 4 and 6 of this act shall, if in custody, be released on bail or on his own bond, unless the public prosecutor has been given an opportunity of being heard on the application of such release, provided that such accused person shall not be released on bail or on his own bond if the court, on perusal of the case diary or the report made under section 173 of the code, is of the opinion that there are reasonable grounds for believing that the accusation against such person is prima facie true.
Correct. So what?
This is the change
Correct.
with the
What we-
IPC law.
What we would like to address the court is that because of 43D and the scheme of UAPA Act, will it also have an overture while framing charge, making it more stringent for the defense side to?
Because the court have to see whether it is satisfied with prima facie satisfaction or not.
Mhm.
Prima facie satisfaction for bail and prima facie satisfaction for framing of charge are no different. Prima facie satisfaction, whether a case is made out against the accused persons or not.
The followed, we are asking a slightly different
Lord.
question. We are saying that in cases where IPC sections, this may actually help your case in a way. Of course, they will have to address. But we are not on whose.
Yes,
cases
no,
will
no,
help
on
us.
academic lordship.
We are on an academic.
There is the opening statement of this
We have to-
discussion.
We have to look at the law
Lords.
and see to what extent it can be expounded. What we are trying to put to you is that the existence of 43D in UAPA,
Lordship,
correct?
lordship.
Does it give an additional handle to the court in favor of the prosecution while
Yes,
framing charge?
yes. In case of bail, yes. It has become more stringent now.
Is that the purpose of the Mr.
Exactly,
Chaudhary?
lordship. That is why it was.
My lord, can I just come
This
in?
is modified. This is additional.
My lord, 43D is in a different context. Otherwise, the reasonable ground expression appears in 437 CRBC and in my lord proviso to 43D5. My lord, it only enlarges the time of my lord filing charge sheet. Nothing beyond that. My lord, 433D has nothing to do with enlarging on bail or something. It is the same satisfaction as we find in 430. Please come to CRBC 437 for a moment, my lord. 437, 1I. 437, 1I. Such persons shall not be so released if there appear reasonable grounds for believing that he has been guilty of an offense punishable with death or imprisonment for life. Now please come to my lord 43D5 proviso.
Yes.
Proviso. Provided that such accused person shall not be released on bail or on his own bond if the court on perusal of the case diary or report made under section 173 of the code is of the opinion that there are grounds, reasonable grounds for believing that accusation against person is prima facie true. There is not much of a difference, my lord. Language is more or less same. Here only they have used the word prima facie case. And here it says, my lord, that there are reasonable grounds for believing that he is the guilty of the offense alleged. In fact, my lord, I would say 437 1I is more rigorous than, my lord, this proviso. Because it says found guilty. That word prima facie is not there. By using the word prima facie, in fact, my lord, the rigors has been lessened.
All right, you can elaborate.
Yes.
So my humble submission is that if the court is to be satisfied prima facie, the trial judge, the Honorable Division Bench, as well as the Honorable Supreme Court believe that there is a prima facie case. So on the same material, there cannot be a turnaround now, only because the stage of the proceeding is at a different stage. Prima facie the materials will have to be same to come to a particular conclusion.
So are you, is that your submission? We are trying to understand your submission that after the Supreme Court has closed the SLP, the trial court had no option but to frame charge.
In one way, yes. On otherwise also, if we revisit the evidences,
No, that part is separate. That we have
Yes.
taken note of. That we have taken note of.
when the division bench says that those things will be decided at the stage of trial. I have read the last line of paragraph.
Hmm.
I have division
So
bench.
according to you, after the division bench judgment, which was,
The hands are basically
the trial court
Already-
had no option but to
no
frame
option,
charge.
no option.
That is your argument.
Yes, Lordship, because already the materials were shifted by the same court, by the higher two courts.
Acha, Mr. Chaudhary, you please address this point. What
Yes, madam.
Mr. Segi, he is saying,
Yes,
just in case you are,
sorry, madam.
what Mr. Seki is arguing, that apart from the materials produced before the court, which was independently sufficient for the court to come to a conclusion.
That
they
there
were
are reasonable grounds to believe.
Apart from that, because of the judgment of the division bench, which he had just read, which had observed that there are prima facie materials, and that judgment having attained finality in the Supreme Court, whereby it was not interfered with. The hands of the trial court was tied to the extent that it could not have taken a different view in the matter. That is that
Yes.
your argument?
Yes, yes.
Please deal with this argument.
I'll do agree.
Completely a reverse
But
term.
because of the judgment, I was wondering whether I will place that 2021 jail. Then now I'll use that also. Then if my learned friend is relying on that judgment, which is in the context of a bail, and in the context of a bail, in case of Sabua, Lordship has already held this is not terrorist activity. End of the matter. Very well.
You argue,
We'll
but-
play draw, my lord.
We'll have a tiebreaker thereafter.
We'll have a,
Tiebreaker. Additional 30 minutes, then tiebreaker. The
you
FIFA
do
final.
whatever you want.
not in
just-
Qatar.
But
Just
My
ensure
lord,
that
no,
next
no,
time-
I'm looking at the watch. The clock is ticking, Lordship, so I have to finish. So first judgment of 1979. Union of India versus Prafulla Kumar Samal. Yes, Lordship. is- Then a subsequent judgment is Sajan Kumar, but I will place 3-4 judgments on this. Paragraph 10,
You have Ghulam Hassan Beg also, Ghulam Hassan Beg.
Ghulam Hassan Beg.
No, all right, you place
Yes,
whichever
yes.
judgment.
Lord.
Yes.
Paragraph 10 says, on consideration of the authorities mentioned above, the following principles emerge that the judge, while considering the question of framing of charges under section 227 of the code, has the undoubted power to shift and weigh the evidence for the limited purpose of finding out whether or not a prima facie case against the accused has been made out. 2, where the materials placed before the court disclose grave suspicion against the accused, which has not been properly explained, the court will be fully justified in framing a charge and proceeded with the trial. The test to determine a prima facie case would naturally depend upon the facts of each case, and it is difficult to lay down a rule of universal application. By and large, however, if two views are equally possible and the judge is satisfied that the evidence produced before him while giving rise to some suspicion, but not grave suspicion against the accused, he will be fully within his right to discharge the accused. My submission here is that we have grave suspicion here. That in exercising the jurisdiction under section 227 of the code, the judge has the judge, which under the present code is a senior and experienced court, cannot act merely as a post office or a mouthpiece of the prosecution, but has to consider the broad probabilities of the case and the total effect of the evidence and the documents produced before the court, any basic infirmities appearing in the case, and so on. This, however, does not mean that the judge should make a roving inquiry into the pros and cons of the matter and weigh the evidences as he has conducting the trial. So these are the 4 principles in 1979. Subsequently,
You are referring to Praful Samal, is it?
yes, Lordship,
Give the Praful Samal judgment.
the citation is here. 1979.
Prafullah Samal.
3 SCC, page 4, paragraph 10. Serially গুছি যাও এটা কোনটো আনিছা AIR 2000 para 4
All right, I have it here.
Yes.
I have taken it.
In our written arguments we will mention all this basically. Book list 1. Then next is state of MP versus SP Johari, AIR 2000, Supreme Court 665. Paragraph 4 says, Lordship, very short.
Yes.
In our view, it is apparent that the entire approach of the High Court is illegal and erroneous. From the reasons recorded by the High Court, it appears that instead of considering the prima facie case, the High Court has appreciated and weighed the materials on record for coming to the conclusion that the charge against the respondents could not have been framed. It is settled law that at the stage of framing of charge, the court has to prima facie consider whether there is sufficient ground for proceeding against the accused. The court is not required to appreciate the evidence and arrive at the conclusion that the materials produced are sufficient or not for convicting the accused. If the court is satisfied that a prima facie case is made out for proceeding further, then a charge has to be framed. The charge can be quashed if the evidence which the prosecutor proposes to adduce to prove the guilt of the accused, even if fully accepted before it, is challenged by cross-examination or rebutted by defense evidence, if any, cannot show that the accused committed the particular offense. In such cases, there would be no sufficient ground for proceeding with the trials. So the law is very clearly elaborated here, Lordship, that conviction may not be considered at the time of framing of charge. Paragraph 4 of this judgment. Then what is a prima facie case? 1974 Criminal Law Journal, 862. 1970 Criminal Law Journal, 862, paragraph 14. On what is a prima facie case and presumption. May I read it?
Yes.
According to Anand Swarup, the word presuming in section 254 indicates that evidence falling short of proof of the commission of offense is sufficient for the framing of charge against the accused concerned. But I do not think that the word can be so interpreted in the context in which it occurs. The two sections are supplemental to each.
Just a minute, you're reading which judgment?
This Anil Kapoor.
Paragraph 14, did you say?
Yes, paragraph 14.
There is no. There is only up to paragraph 9 here. It's something.
I can give you a copy also.
Yes.
According to Anand Swarup, the word presuming in section 254 indicates that evidence falling short of proof of the commission of offense is sufficient for the framing of charge against the accused concerned. But I do not think that the word can be so interpreted in the context in which it occurs. The two sections are supplemental to each other and harmonious constructions must be placed on them. Section 253 states in categorical terms that the magistrate is bound to discharge the accused if no case is made out against the latter, which, if unrebutted, would warrant his conviction. In other words, if the evidence produced as it stands is not sufficient for a conviction, the magistrate is duty bound to discharge the accused. If in this context, the word presuming in section 254 clearly envisages that the framing of a charge against the accused only if the evidence before the magistrate is sufficient to warrant a conviction. In advancing an argument to the contrary, Mr. Anand Swarup had said that before the charge, the prosecution is to make out only a prima facie case. as held by their lordship of the Supreme Court in Mahant Abhay Das versus Gurdayal Singh. And a prima facie case does not mean a case of the type envisaged in section 253. The first part of his argument is unexceptionable, but I cannot agree with the second part of it. What is a prima facie case? According to Webster's International Dictionary, prima facie case means a case established by prima facie evidence, which in turns means evidence sufficient in law to raise a presumption of fact or establish the fact in question, unless rebutted. It is thus apparent that a prima facie case is nothing more or less than a case of the type of mentioned in 253. Nothing contained in the judgment of their lordship cited above contains a hint that the phrase prima facie case carries even a slightly different meaning. So prima facie case, lordship, the materials has to make out a case of a allegation of the offense. Unless it is rebutted, it has to be taken as a accepted one. So when will the rebuttal take place? The rebuttal will take place at the time of cross-examination or the evidence from the other side. So that will take place only at the stage of trial. So whatever statements, all these conversations, statements of the witnesses, the other technical evidences, make out a particular line. There cannot be two opinions on that there is a conspiracy to disrupt the government activities during those time, that 1 week time, when the Prime Minister of Japan was to visit Assam. That is one part. There is another part is that A1 was taking boys from his organization KMSSS and send them for training in Odisha. This has to be rebutted. And those persons who took training, they have given statements. In cross-examination, that can be demolished. The protected witness A, protected witness B, they are part of the same team, same organization. They said that I, along with 4, went to Odisha for training. Whether he has gone or not, in the cross-examination, everything will come out. He has given that statement before the IO or before the magistrate, either 161 or 164. So my humble submission, prima facie case has been established. In the trial, we have to prove them beyond all reasonable doubt. Then only he will be convicted or the other 3 will be convicted. Just having the allegation that charge is framed, that does not mean that the case is wholly against him. The acquittal rate is very poor in our country. Lordship knows that.
Acquittal or conviction,
Sorry, conviction, reverse.
but not in near matters.
Not in NIA matters. NIA, that is why all the cases of NIA were discharged. All the cases. That is why it is a issue of their reputation also. NIA is a very sophisticated investigating agency. If Lordship look at all the evidences, I have not found this kind of evidences in our state police investigation, unless there is a special SIT. But here, the base of the countries are picked up and they are doing the investigation. In fact, a sanction has also to be given before prosecution. That is section 43. 40? 45. The government looks before filing the search sheet. Section 45 of the.
Yes, that is to be done by the secretary.
Yes, Lordship. So we do not want to go and cut a sorry face before the court. Everybody looks into it.
But that's fair enough. These are,
Then there's a review committee also. So all Sabwa, Chanmari, all brush aside by a stroke of a pen.
is there a possibility of improvement of the prosecution and
In the state, yes. State, yes.
and investigations
Yes,
in
yes.
the state?
We have already.
Since you reminded us just.
Yes,
now,
Lordship, we have already.
It's painful, to say the least.
I know, Lordship, the time is taking, but already in the last cabinet, we have already taken the decision. It is already in the formal stage, final stage of the notification for advertisement. So that the director of prosecution and deputy directors of prosecution, that is one part. The other part, we have already framed the rules for appointment of the PPs in the district. Everything will go, Lordship will see the changes in 1 or 1.5 years time.
No, that will
The
be
long
good.
legacy, it takes time to change, Lordship.
That is correct.
So I hope the good advocates will come and take the post of this Director of Prosecution and Deputy Director of Prosecution. They will be the fulcrum of the activities.
Yeah, but one just hopes that whoever takes over these offices will just not sit back and relax, but really do
We
some
have
work.
a cross checks and balances there also. We are trying to do that. One person or one team cannot change the whole system, Lordship. Everybody has to feel that he has a particular role to play for overall benefit of the society. The police is doing their best to nab all the drug peddlers. Now, if the lawyers, I mean, who are at the prosecution side, if they are not doing their homework properly, they will get the free road to
So
the
that is what is
liberty.
happening.
That is what is problem. Or
That
to,
is happening.
because it has to be perfect from all aspects. There are several organs, several parts. Lordship knows that. I don't have to say.
So that is
It-
correct.
Police
Ultimately,
is now doing superb work. My friend will also agree, hopefully.
police is now doing,
Good work. 721 crores drugs were nabbed during the last year.
that's correct.
Drug police have done good job.
That's
Only
correct.
thing is they have done excess also. You must say that also.
We'll keep that for
I'll
another.
understand. Here's the other side of the story. That is why
We-
he's
No,
giving
no,
a,
no.
he's
All-
just giving a balance.
All throughout my life, I have maintained that I'll continue to do that till I die, my lord. I'll not make a statement to please somebody. I'll make a statement which I think will come out of my conscience.
What is that statement?
That statement is, yes, so far as, drug menace is concerned, state government has really addressed it very well. But while doing so, they have committed a lot of excess. Because we are governed by rule of law. That's all.
Accepted.
So this is the next judgment will be Lordship. To 1989, 1 SCC, page 715, para 14. Satish Mehra versus Delhi administration.
Mr. Saikia, before we go on to the judgment, you said prima facie case means once the prosecution comes up with the materials, that is prima facie case. And this can be rebutted only during trial
Trial.
at the time of cross-examination,
This is what the courts are saying.
which judgment is saying.
And
Because the prima facie
let me
case.
place all the judgment in some of the judgments. This is a
Correct.
specific. Fine.
See, this interactive process
Yes.
also opens up
Yes, yes,
minds,
Lordship.
and we need to discuss.
Definitely,
this.
Lordship.
The young lawyers sitting, they will also get to learn. a
Lord,
few
Yes,
things. See, prima facie case at the stage of framing charge.
If we take it as face value without any plus or minus,
So there is
Lordship,
no question of evidence
Yes.
here.
no evidence.
What evidence
Yes.
doesn't come in?
No, some evidence do come in
No, where is
at the
the-
stage of framing of charge, because
Where is the
that
evidence?
Huh?
Which is the evidence?
evidence which are part of the, which are the materials in the charge sheet,
That's not evidence.
that is not evidence after the trial,
That's
but
not
the
evidence.
materials which are placed, which are the materials the court have to look at.
Materials,
FIR
not evidence.
Yes,
whether the materials can be converted into legal evidence during trial.
That is
that
the
is the
yes.
later stage.
No,
But at the
materials,
moment,
mat-
it is only on the basis of materials
Yes.
accompanying the charge sheet. The prosecution will try to show that a prima facie case has been made out
Lordship,
to proceed
yes,
and subject the accused to trial,
Lordship,
which cannot be done unless charge is framed. And it will be open for the defense side to show that these materials taken on the face value,
are
sum
no
total,
materials.
cannot lead to conviction from whichever angle it is viewed.
exactly.
Therefore, this is a fit case for discharge. That is the short area where whole thing
Lordship.
operates. If the prosecution succeeds, then of course, as you know, the matter goes to trial and then evidence, testimony, cross-examination, rebuttal, this will come. But here, the expression rebuttal probably is, that is why I am mentioning it. The expression rebuttal used in this judgment is probably in the context that rebuttal by argument, by you displace the the contention.
That even prima facie case does not
Yes,
exist.
that contention is to be rebutted, not the material, because the defense side cannot bring materials at this stage. The materials before the court at the stage of framing charge is only what is in the charge sheet or the supplementary charge sheet. So the question of the defense side bringing material does not
No.
arise at all.
They have to rebut.
They have to rebut the contention, displace the contention on the basis of the materials in the charge sheet, not their own material.
The Supreme Court in this case of 2000, which I have placed,
Hmm.
the party's name is State of MP versus Johari. Paragraph 4, I am reading once more.
Yes, please.
In our view, it is apparent that the entire approach of the High Court is illegal and erroneous.
Hmm.
From the reasons recorded by the High Court, it appears that instead of considering the prima facie case, the High Court has appreciated and weighed the materials on record for coming to the conclusion that the charge sheet against the respondents could not have been framed. It is settled law that at the stage of framing of charge, the court has to prima facie consider whether there are sufficient grounds for proceeding against the accused. The court is not required to appreciate the evidence.
That's correct. But why the
The court is not required to appreciate the evidence and arrive at a conclusion that the materials produced are sufficient or not for convicting the accused. If the court is satisfied that a prima facie case is made out for proceeding further, then a charge has to be framed. The charge can be quashed if the evidence which the prosecutor proposes to adduce to prove the guilt of the accused, even if fully accepted before it, is challenged by cross-examination or rebutted by defense evidence.
So this is what it has caught my attention also, but
If it cannot show that the said accused committed the particular offense. So that second part, cross-examination and rebuttal by defense, it is a part of the trial.
then why it was used
That
in the,
Supreme Court has said, Lordship.
that is what has caught my attention.
Yes, Lord.
That's why I came back.
That's why I said I have placed it. So
The-
that is why if the prima facie court is satisfied with the materials,
That's correct. It's the materials.
materials.
There is no evidence
But
at this stage.
sometimes the honorable court have
Maybe
also
it was-
loosely used the word evidence.
Just to interrupt, my lord, there is an answer to that also. Honorable Supreme Court has said when
I'll
High
let
Court.
me place my cases,
No, I am
Lordship.
not on case, but I am on this particular aspect. Where if the Honorable Supreme Court has said, if High Court finds that Honorable Supreme Court has taken two views on a particular point, then High Court should prefer larger bench decision, that's all,
All right. Yes.
not on merits.
कौन सा है 1989 दिखा दिया 1989 one SCC page 715.
Free attachar Virod Parishad.
Yes. Paragraph 14. The two decisions do not lay down different principles. Prafulla Kumar case has only reiterated what has been stated in Ramesh Singh's case. In fact, section 227 itself contains enough guidelines as to the scope of inquiry for the purpose of discharging an accused. It provides that the judge shall discharge when he considers that there is no sufficient ground for proceeding against the accused. The ground in the context is not a ground for conviction, but a ground for putting the accused on trial. It is in the trial the guilt or the innocence of the accused will be determined and not at the time of framing of charge. The court therefore need not undertake an elaborate inquiry in shifting and weighing the materials, nor it is necessary to delve deep into various aspects. All that the court has to consider is whether the evidentiary materials on record, if generally accepted, would reasonably connect the accused to the crime. No more need to be inquired into.
Yes. So anyway, the principles are well settled. You may
Well
not-
settled, well
you need
settled.
not labor much on that.
Lord.
There's no need to multiply.
That is a one paragraph from all these statements. State of Maharashtra versus Somnath, 1996, 4 SCC, page 659.
Page কিমান হ'লে?
Page 659, paragraph 29, 30, 31, and 32. 29 says, what was stated in this regard in same judgment, which was quoted with approval of paragraph 78 in State of West Bengal versus Mohammed Khali, is that what the court has to see while considering the question of framing of charges whether the materials brought on record would reasonably connect the accused with the crime. No more is required to be inquired into. In Antule's case, Justice Bhagavati opined that noting the difference in the language of the three prayers of section, that despite the difference, there is no scope of doubt that at the stage at which the court is required to consider the question of framing of charge, the test of prima facie case has to be applied. According to Sri Jethmalani, a prima facie case can be said to have been made out when the evidence, unless rebutted, would make the accused liable for conviction. In our view, a better and clearer statement of law would be that if there is a ground for presuming that the accused has committed the offense, a court can justifiably say that the prima facie case against him exists, and so frame a charge against him for committing that offense.
Right.
May I read it once more, last line? In our view, a better and clearer statement of law would be that if there is ground for presuming that the accused has committed the offense, a court can justifiably say that a prima facie case against him exists. So frame a charge against him for committing the offense. Let us note that the meaning of the word presume in Black's Law Dictionary, it has been defined to mean to believe or accept upon probable evidence. In Shorter Oxford English Dictionary, it has been mentioned that in law, presume means to take as proof until evidence to the contrary is forthcoming. In Stroud's Legal Dictionary has quoted in this context a certain judgment according to which a presumption is a probable consequence drawn from facts, either certain or proved by direct testimony, as to the truth of the fact alleged. In Law Lexicon, Ramnath Iyer, the same quotation finds place at page so and so. The aforesaid shows that if on the basis of materials on record, a court could come to the conclusion that commission of the offense is a probable consequence, a case for framing of charge exists. To put it differently, if the court were to think that the accused might have committed the offense, it can frame the charge, though for conviction the conclusion is required that the accused has committed the offense. It is apparent that at the stage of framing of charge, probative value of the materials on record cannot be gone into. The materials brought on record by the prosecution has to be accepted as true at that stage.
Yes, yes, absolutely.
Nineteen 9 SCC page 766. Satish Mehra versus Delhi Administration. 1996, volume 9 SCC page 766, paragraph 13. What if I'm skipping this? It is not very relevant. Paragraph 13, similar, it is not very relevant. 1994, 4 SCC page 142, Meenakshi Bala versus Sudhir Kumar. Paragraph 6, 1994. Paragraph 6. Meenakshi Bala versus Sudhir Kumar, paragraph 6. Having regard to the facts that the offences for which charge sheet was submitted in the instant case and cognizance taken was trialable as a warrant case, the magistrate was to proceed in accordance with section 239 and 240 of the code at the time of framing of the charge. Under the above sections, the magistrate is first required to consider the police report and the documents sent to it under section 173 and examine the accused. if he thinks necessary and give an opportunity to the prosecution and the accused on being heard. If on such consideration, examination and hearing, the magistrate finds the charge groundless, he has to discharge the accused in terms of section 239 CRPC. Conversely, if he finds that there is ground for presuming that the accused has committed an offense trialable by him, he has to frame a charge in terms of section 240. So basically the presumption and reasonableness.
Yes, that is the reason the expression evidence is a little surprising because
Lordship, that
framing
was
of
loosely
charge
used word
always-
actually.
it's presumption. It's a
Presumption.
Presumption. The
And it was
presumption must,
materials, not evidence.
presumption must be based on reasonable
Yes.
materials.
2006, 4 SCC page 51, Rajbir versus State of UP, paragraph 10. The High Court did not at all apply the relevant test, namely whether there is sufficient ground for proceeding against the accused or whether there is ground for presuming that the accused has committing an offense. If the answer is in the affirmative, an order of discharge cannot be passed and the accused has to face trial. So the High Court did not apply the relevant test that whether there is a sufficient ground for proceeding against the accused or whether there is ground for presuming that the accused has committed an offense. If the answer is in the affirmative, an order of discharge cannot be passed and the accused has to face the trial. Or privity, it was given 2018. 2018 13 SCC page 445. Selby. Two 2018-13 SCC page 455. Selby, State of State versus Selby. State by the Inspector of Police Chennai versus Selby. Paragraph 10.
Paragraph 10.
Paragraph 10. Other paragraphs are also relevant.
Hmm.
7, 8 in 7. They have relied upon the major judgments, Lordship.
Hmm. You wanted to rely on Sajan Kumar also.
Sajan Kumar also. I am coming to that. So Sajan Kumar is considered here.
Ah,
So paragraph 7 is Sajan Kumar.
yes.
Then paragraph 8 is Arun State versus Arun Kumar and few other cases. 9 is also there. The Sajan Kumar I will place separately, but I am coming to paragraph 10 of this judgment. If on the basis of the materials on record, the court would form prima facie opinion that the accused might have committed the offense, it can frame charge. Though for conviction, it is required to be proved beyond reasonable doubt that the accused has committed an offense. At the time of framing of charge, the probative value of the materials on record has to be gone into, and the court is not expected to go deep into the matter and hold the materials would not warrant conviction. The court is required to evaluate the materials on the record at the stage of section 227 or 239 of the code, as the case may be, only with a view to find out if the facts emerging therefrom taken at face value discloses the existence of all the ingredients constituting the alleged offense. It is tried that at the stage of consideration of an application for discharge, the court has to proceed with the presumption that the materials brought on record by the prosecution are true and evaluate such materials with a view to find out whether the facts emerging therefrom taken at their face value disclose existence of the ingredients of the offense.
Mr. Saika, we know you are in a hurry to conclude, but some observations with all respect, very probative value of materials. Now, probative value, as far as I understand, is of evidence. Probative value is what is the force of the evidence to prove.
Exactly.
So normally a material will not have a probative value. It will be the evidence which will have a probative value. But I find that the Honorable Supreme Court has used this expression at the time of framing of charge. The probative value of materials on record.
With a
Has
view
to be
to find
gone.
whether the
Hmm.
facts emerging at their face value. They get that prima facie.
No, that's what, but the probative value of the materials.
Lordship will see now what is a probative value. Suppose this telephonic conversation,
Hmm.
if we are not having the report from the forensic that these are the authentic voice of the person,
There is no probative value.
there is no probative, but we have the certificate also for them.
No, what I'm saying is, first of all, these have to be tendered in evidence.
Tender as a material, yes.
In evidence,
Yes.
this, whatever you have in your chart. See, the problem is, you may not be able to conclude it today, but these are very relevant issues. We have to, if not directly involved in this case, please point out if you have a difference in opinion. We'd like to hear both the senior counsel on this. Very short issues, but has very deep significance
yes.
because we are doing matters every day on this. A material in the charge sheet is the outcome of investigation, correct? But it may so happen that during trial, none of these materials could qualify to become admissible in evidence. For example, you may find a witness deposing the same person, but he may turn hostile.
Yes.
Which you don't know. You may find that he has not exactly supported his 161 statement. There could be contradictions, there could be improvements and anything. So if that witness remains intact in his cross and suppose the IO statement recorded to IO, his evidence will have a probative value. If he turns hostile, his evidence will have very low or negligible probative value. So ordinary sense, what we understand is probative value is the force of that evidence, which goes to prove a particular fact,
Yes.
prove or disprove.
Yes.
So proof or disprove is always dependent on evidence, not on anything else. Correct. So the qualitative value of the evidence is what is directly related with
Yes.
the probative value of the evidence.
Now, we have 19 witnesses.
Hmm.
We do not know who will turn hostile or not.
You know,
But
yes.
that situation will come once the trial starts. At the stage of framing of charge, we cannot go and look into that situation or apprehend such a situation. So now trial has not started. The strength of those evidence, these materials will be tested
That's
at
all
the
right.
trial.
We're not on that part.
Okay,
I'm saying, trying to understand why the expression probative value has been used in this paragraph, where the stage of framing of charge, just trying to understand it. There
Yes.
must be something that we are missing out.
probative value at the stage of framing of charge and probative value at the time of giving the conviction or acquittal
These are
will
different.
be on two different parameters.
Okay. All right, you proceed, please.
Yes. So this paragraph also very clearly last few lines says, if it is a tried that at the stage of consideration and application for discharge, the court has to proceed with the presumption that the materials brought on record by the prosecution are true. Court has to believe us, trust should be on the prosecution. And evaluate such materials with a view to find out whether the facts emerging therefrom taken at their face value. It is not tested. So we have to believe what is placed before me. Disclose existence of the ingredients of the offense. Section 18,
Yes.
Terrorist Act, section
So these
50.
principles are firmly settled. No-
Firmly
no
settled.
further. Yes.
One more lordship, this Sajjan Kumar. Sajjan Kumar lordship, then I will not place that judgment separately. Paragraph 7, 8, 7 is Sajjan Kumar of the last judgment.
Yes.
8,
In
9,
Sajjan Kumar, you wanted to rely on para 10.
yes.
what?
19, paragraph 19 of Sajjan
19.
Kumar, because the other side also relied upon this. Paragraph 19 very clearly says, I would like to place paragraph 19.
Yes.
Sajjan Kumar is lordship. 2010 9 SCC page 368, paragraph 19 says, it is clear that at the initial stage, if there is nothing a strong suspicion which leads the court to think that there is ground for presuming that the accused has committed an offense, then it is not open to the court to say that there is no sufficient ground for proceeding against the accused. The presumption of the guilt of the accused, which is to be drawn at the initial stage, is only for the purpose of deciding prima facie whether the court should proceed with the trial or not. If the evidence which the prosecution proposes to adduce, here it is very interesting also. If the evidence which the prosecution proposes to adduce proves the guilt of the accused, even if fully accepted, before it is challenged in cross-examination or rebutted by the defense evidence, if any, cannot show that the accused committed the offense, then there will be no sufficient ground for proceeding with the trial. A magistrate inquiring into a case under section 209 is not an act of mere post office and has to come to a conclusion that the case before him is fit for commitment of the accused to the Court of Sessions. He is entitled to sift and weigh the materials on record, but only for seeing whether there is sufficient evidence for commitment, but not whether there is sufficient evidence for conviction. If there is no prima facie evidence or the evidence is totally unworthy of credit, it is the duty of the magistrate to discharge the accused. On the other hand, if there is some evidence on which the conviction may be based, he must commit the case. It is also clear that in exercising the jurisdiction under section 227 CRPC, the magistrate should not make a roving inquiry into the pros and cons of the matters and weigh the evidence as if he was conducting a trial. And
Yes.
2020-12 SCC page 467, paragraph 25. Nalla Para Reddy, Sridhar Reddy versus State of Andhra Pradesh, paragraph 25. The veracity of the deposition made by the witnesses is a question of trial and need not be determined at the time of framing of charge. Appreciation of evidence on merit is to be done by the court only after the charges have been framed and the trial has commenced. However, for the purpose of framing of charge, the court needs to prima facie determine that there exists sufficient materials for the commencement of the trial. The High Court has relied upon the materials on record and concluded that the ingredients of the offences under section 406 and 420 are attractive. The High Court has spelled out the reasons that necessitated the addition of the charge, and hence the impugn order does not warrant any interference. So basically the materials which we produce, whether that will make out a case and have the ingredients of the offense alleged. If that is there, then there is no point of discharging. If Lordship give me 10 minutes, then I can handle the judgment and I can conclude.
Yes, yes.
How nice judgment appeal to. Now coming to the impugned judgment, which Lordship will find at page 41.
Yes.
So we have done our part of hearing for 3 months, according to the learned trial judge. So he has noted one simple paragraph, paragraph 3, page 42. A short paragraph.
Yes.
So this was our submission, which the learned trial court has recorded for 3 months' time. And next page, Lordship will see paragraph 4. Hertz Ahmadi so-and-so of the Supreme Court, assisted by so-and-so, also perused the written arguments, 1225 pages written arguments. Then all the narrations, 4, then the second counsel, paragraph 5, paragraph 6, all the judgments up to page 46. So this is their side. So in 3 days, the Honorable Court recorded 4 pages, and for our 3 months, he recorded not even half page. Then the narration of various judgments, materials against the persons. Here, paragraph 13, page 91, also noted the documents. which I have placed this morning before this honorable court. Then page 105, analysis and findings regarding Manos score. Out of 19 witnesses examined during the investigation who are listed in charge sheet, 2 protected witness and list so and so have not mentioned the name, whereas witness number 9, 10, 15 of the charge sheet dated have mentioned Manos scores but have not implicated him. Witness number 5, charge sheet so and so has stated that Manos score, Manos protein score along with Okiko, but he has not implicated him. Paragraph 65. The telephonic conversation and CDR analysis definitely indicate Manos score was involved in protest against the CA, but there was also some materials about his coordinating such protest with others, including co-accused. So he has accepted one part. Paragraph 65, first 4 lines. So he himself is satisfied that CDR analysis definitely indicate Manos score was involved in the protest and the protest were violent protest. The other records clearly prove it. Then relying upon Kedar, it does not constitute sedition. Then paragraph 70, it was against Dhojjo Kumar. So he came to a conclusion that Manos Kumar is not involved. Then Dhojjo Kumar, paragraph 70 onwards.
76.
And very interestingly, paragraph 79 says, upon perusal and analysis of the statements of witnesses Sunil Sonowal, Hussein Mohammed, etc., it is clear that KMSS and its associates were involved in planning, coordinating, and executing protest activities against the citizenship law proposed and later passed by the government. So he has accepted all this part. In this context, judicial notice can also be taken around the relevant time that there are a lot of protest activities of the state over this. Whether that is permissible, Lordship, judicial notice. It is not permissible in law. The materials placed before the Honorable Court. The Honorable Court will have to only look. He cannot bring his own personal knowledge. In this context, judicial notice can also be taken, which is not permissible. I have judgment of the Bombay High Court on that point. I am not troubling with your Lordship. These are settled positions. What can be looked into? Whether it is a 227 application or 482 application, CRPC. Carried out by various people involving burns, disruption of transport, supplies, and unfortunately, the protest led to violence and damage to property. All this he has written. Unfortunately, these protests led to violence and damage of property. However, there are no prima facie materials to connect Dhojjo Kumar to an incitement of violence and vandalism. Everything was orchestrated over those telephone discussions and all those maneuvering. The records clearly establishes that. From where these findings, this is in my humble submission, the perverse finding. Then, paragraph 84. The telephonic conversation, the CDR analysis, and the statement of some of the witnesses clearly indicate that Sri Dhojjo Kumar was involved in protest against CAA. But more is required. It is not that only CAA protest was the part. Had it been a non-violent agitation, Lordship, this case would not have cropped up. It was only because in the CAA agitation, Lordship, lot of violence had taken place. Offices were damaged, railway stations were burned down, vehicles were burned down, police officers were injured, roads were blocked. So, own findings. So, these are self-contradictory findings. Now, paragraph. My learned friend referred to 110 about section 15. I have placed the section 15. It is an unambiguous provisions of law. Then paragraph 12, the Sabwa case also. Paragraph 114 says, however, as stated above, from his speeches available on record, A1 cannot be imputed with any incitement to violence. There are also no materials to link A1 to vandalism and damage of property that took place during the said CAA protest due to such agitation led by various organizations. This is a finding. I have placed the materials before this honorable court. Statement of the page 126, paragraph 117. A1 is stated to be talking to closer and blockade. It also revealed that the statement that on next day shops, markets were automatically closed. In the statement of W4, A1 is stated to be talking to shut down the town of Sibsagar. From the expression supervising execution of the bond against CAB, in the statement of witness Shah Jahan, it cannot be automatically inferred prima facie that accused had instructed the destruction of essential supplies and the same amounts to abatement or the commission of an act of terrorism defined in section 15 of the act. Further, there is also no telephonic conversation with regard to non-listing witness Shah Jahan. There is specific evidence, Lordship, I have placed this morning that he asks one of his subordinate to go and meet the police station master and tell him to cancel the train. He has instructed another person that at 4 o'clock, the other person suggested that the train will be released for movement. He said, don't do that. Isn't that sufficient that he is doing blockade of the communication system, disrupting the life of the society? One to minor instances. There are a lot in the evidences, in the materials. I am also using the same in the materials. Paragraph 120. There is one statement at the end about stopping transportation of natural resources of Assam. That speech, that YouTube channel speech. There is no material to indicate that such stoppage of natural resources from this part of the country to the rest of the country as a result of any such statement of A1. Moreover, the statement alone cannot be used to impute frame charge of terrorism. What more is required? Section 15 is very clear. Even if you advise, even if you abet, it is sufficient. You don't have to do. And Section 18 says, whoever conspires or attempts to commit or advocates, abets, advises, incites, directs, knowingly facilitates the commission of a terrorist act or any act preparatory to the commission of a terrorist act shall be punishable with imprisonment, which shall not be less than 5 years and above. So the law very clearly says that even if you advise, even if you incite, those speeches are there. The learned trial just simply says this is not sufficient. So we have to rewrite the law, section 15 and section 18. Then paragraph 122. On the basis of the statements of some of the witnesses about A1 speaking about blockade and closure, it cannot be said that there are prima facie materials to indicate that such talk of blockade was an intention to threaten the economic security of India. One had stopped all transportation of natural resources from Assam to rest of the country. Very clear speech with all electronic evidence. And the learned trial just says that that is not sufficient. Paragraph 123, even if the statements of some of the witnesses attributing talk of shutdown, etc. to A1 are acceptable on face value, in the backdrop of any non-incitement to violence and appeal for peace in his speech in D56, it cannot be said that there is a prima facie case for interfering. Therefore, I am to consider the opinion that statements and conversations do not make out any offense under 18 UAPA Act of conspiracy, abatement, advice, advocacy of terrorist act as defined in section 15. If all these materials are nothing, mere waste paper, then Lordship, I have no case at all. But if we apply our mind with the contents, then there is definitely something to get tested. It is not that these are sacrosanct or these are like the paragraphs of the Bible. It has to be tested. Whatever statement these persons are giving before the police or before the magistrate, or the evidences from the this forensic science laboratories and the other technical evidences, it has to be put to test.
Still the order of discharge, they were in custody.
Yes, they were in custody.
They were-
One was in custody.
Accused
Who-
one.
Accused number one.
One.
Who is accused number one?
Akhil Gopal. He was in custody, rest were granted bail.
Because the same court rejected bail, High Court also rejected bail, Supreme Court also rejected bail. That is why he is behind the bar. It is not the police who kept him. The prima facie case was there. Section 43D provides us clearly proves
That's all.
that prima facie materials are there. Therefore, none of these courts was pleased to grant him bail. It is not that we have forcefully kept him under these barriers or the cell. No, it is not like that. He was tested at the highest level of the court. So there cannot be any negative attribution to NIA that we have illegally detained him. We have detained him and it was tested before all the three forums available to him. Hardly 5 minutes, Lordship. I'll take.
Yes, yes, please, please.
Then paragraphs 128. The concept of the Offense of Terrorist Act under Section 15 essentially postulates a threat or likely threat to the unity, integrity, security, and sovereignty of India, or striking terror amongst the people of India or in foreign country, and to compel government of India and the government of a foreign country or any other. The offense of terrorist act under Section 15 and the offense of unlawful activities under Section 210 of the UAPA have some elements of commonality. The essential element in both is the challenge or threat or likely threat to the sovereignty, security, integrity, and unity of India. While Section 15 requires some physical act like use of bomb and other weapons, Section 210 takes its compass even written or spoken words or any other visible representation intended to or which supports the challenge to the unity, sovereignty, integrity, and security of India. The said offenses are related to the defense of India and are covered entry 1 of Union list. In the backdrop of the aforesaid discussion, I have the considered opinion that burns, blockades, shutdowns, etc., part of some protest unaccompanied by incitement to violence would not come within the ambit of the expression threatening the economic security of India. Rather, the said expression has a much graver connotation. As already stated, there are no materials to link A1 personally and vicariously with the vandalism and property damages that took place during the protest in December 2019. At the relevant time, there are overlapping agitations led by various organizations during which the unfortunate vandalism also took place. Materials to support prima facie linkage of A1 personally and vicariously with the specific incident of vandalism are not there in my considered opinion. So this is the opinion expressed by him. But if we look at all the telephonic conversation, who was the mastermind of organizing this protest? So vicarious liability is always there. How many people should be gathered in a particular place? 20,000 or 500, everything has been instructed. If those telephonic conversations are fake conversations, then that is a different story. But that will have to be tested in the trial again. In view of above and the context of the materials indicated, A1 in his speeches did not incite violence and rather appeal to the people to maintain peace and not indulge in violence. Document D56. The statement of some witnesses attributing talk of shutdown, blockade, and closure on the part of A1 cannot be constituted to mean prima facie that A1 advocated or advised commission of a terrorist act with the intention to threaten the unity, integrity, sovereignty, security, or economic security of India, or with an intention to strike terror in the people. In my considered view, interpreting otherwise would be incorrect and too far-fetched a conclusion, stretching the definition of Section 15 beyond permissible limit for the purpose of framing against A1 for offense of terrorism. Further, the fact that there is no an iota of materials about A1 making imputations regarding prejudicial to the integrity and sovereignty of our country also has a bearing on overcoming of his findings for the purpose of framing charge. Pausing here from a moment, Lordship. Again, Section 15. Section 15 and 2L, no? Hmm. 12 terrorist gang means an association. No. O is the unlawful activities definition, and section 15, the terrorist act. Whoever does any act with intent to threaten or likely to threaten the unity, integrity, security, economic security or sovereignty of India, or with intent to strike terror or likely to strike terror in the people or any section of the people or in any foreign country, by any other means of whatever nature to cause or likely to cause, Roman 2, loss or damage or destruction of the property, disruption of any supply of or services essential to the life of the community in India or in any foreign country. And 4, damage and destruction of any property in India. So there are direct materials to show that he was instrumental in requesting his subordinates to stop the roads, shut down the whole state of Assam, shut down Dibrugarh, shut down Sibsagar, shut down Jorhat, shut down Guwahati. And he is also instigating the people to gherao Janta Bhavan and also gherao the residence of Honorable Chief Minister, then Chief Minister, and the then Finance Minister. All these evidences are there. Everything is very clearly written. If it is to be true, it has to be brushed aside and it has to be tested. Whether these statements made by the persons or these materials found out by the investigation team are correct or not, whether these are manufactured documents, whether these are manufactured doctored evidence.
No, that is different.
So these findings is very difficult to accept, Lordship, in my humble submission. These are perverse findings. The opinion is given in such a casual manner. Then paragraph 132, protest in a democracy. He is defending now the Learned Singh trial judge. Protest in a democracy are sometimes seen to take form of blockages, also even causing inconvenience to citizens. However, it is doubtful that such blockages for temporary period, if unaccompanied by any incitement to violence, would constitute a terrorist act within the meaning of section 15 of the UAPA. That in my mind is beyond the intention of the legislature. There can be other laws to address that. Yes, other law was there, IPC provisions were also there. So if he was so unhappy with UAPA provisions, the other provisions still survive. That will also not make it a fit case for discharge. He could have committed it to the other court, the Sessions Court, for trial under IPC provisions. Thereafter, this judgment is discussed on section 15 and 18. Paragraph 138. Since there are no materials regarding incitement to violence by Akhil Gogoi and lack of materials linking him personally vicariously to vandalism, property damage, etc. during the car protest, it is not possible to come to any prima facie finding that A1 caused public disorder through incitement of violence or tried to overthrow duly elected legitimate government through violent means or as to tie him to sedition. So sitting with his companions on the railway track, standing there, giving speech, all these photographs are there. So these are not considered by the learned trial judge. And Supreme Court on and off in Kerala case and in Guwahati High Court also says, band is a unconstitutional action. It is illegal. Then 124, I am skipping today for the simple reason that Supreme Court says that for the time being, keep a hold. Then page 135, 141, it is regarding 120B, conspiracy part. Paragraph 155. On the face of it, the statement of protected witness A and protected witness B appears implicating. However, on slightly closer look, I am of the considered view that they suffered from significant infirmities even for the purpose of framing charges. So at this stage, I should not make any comment because the language is very clear. How he was managing his team members or his organization members for various training programs. He has given an example, 156. For example, except for one instance, all other activities referred to have taken place before 2009, when CPI Maoist was still not a banned terrorist organization. Even with regard to the one instance of 2009, the statement of PB2 is completely vague as to which part of 2009 the said activity took place. There is very significant, this is very significant because the Gazette notification dated 22/6/2009 of Government of India, CPI Maoist was declared banned organization only with effect from 22/6/2009. Therefore, even if the statements of the protected witness is accepted on face value, the possibility of the said activity of 2009 having taken place prior to 22/6/2009 when CPI Maoist was yet to be banned remains wide open. Thus, clearly two views have emerged for the prima facie for determination on the point of charge. In this context, it may be made that to the leading case of Sajjan Kumar, in which one of the principal laid down regarding consideration of charge is that if two views emerge, there is no grave suspicion, but only perhaps suspicion of the court would be justified in discharging the accused. Accepting this everything, but the learned trial judge has not taken the fact that there is another group which is envisaged under the UAPA Act, that is unlawful gang. For unlawful gang, there is no requirement of any notification under Section 3. Unlawful, these terrorist gangs means any association other than terrorist organization. Terrorist organ, there that notification Schedule 1 has to be there, whether systematic or otherwise, which is concerned with or involved in terrorist act. So KMSS, his members were taking training from the CPIM.
That we have noted.
Now, the same KMSS members are part of these agitations. And whatever they have learned from their training, it was being used during the Ka agitation. So there is a sequence of events. So only saying that this notification came on 22/6/2009 will not absolve them from the allegations of the offense committed under Section 15. Secondly, paragraph 157, also hardly 3 minutes. The period of time referred to by the protected witness regarding activity 2004, 6, 7, 8, and 9, but in their statement recorded in 2020 after a gap of more than 11 to 14 years. For example, the PAO has mentioned the incident of 2008 and his participation in this activity statement before the Metropolitan Magistrate of Delhi recorded in 3/3/2020. There is a gap of 12 years. My humble submission is that that is not a ground to give discharge. We have found all these persons now. So there is no bar that I cannot take the evidence or the witness's statement who is narrating a story of 2008 or prior to that in 2020. So this cannot be a ground for discharge. Paragraph 1757. Then mens rea party is there. Paragraph 161. From the section of 39, it is also clear to constitute an offense. That section, the activities mentioned therein has to be done in requisite mens rea with the intention of furthering the activity of a terrorist organization. So after June 2009, Lordship, KMS has actively involved with the activities of CPI-ML. The documents which I have furnished in the morning, Lordship, the seizure list of all those documents, and the trained persons were part of the agitation now. They are basically doing the activities which the terrorist organization actually is doing. Paragraph 163, in the backdrop of the aforesaid position with regard to the statement of PWA, PWB, even if the aspect of date of on 22/6/2009 is overlooked, the statement is accepted. It is doubtful that whether such materials prima facie constitute giving support to terrorist organization with the requisite mens rea for furthering its activities so as to fall within the meaning of either the three clauses A, B, and C of section 39. This is going beyond the purview of the court, lordship, at that stage. Then additional materials, paragraph 168, 169. Protected witness sees is analyzed. Here, paragraph 170. Thereafter, on 29/6/2021, petition 195 of 2021, the NIA has submitted a supplementary report by way of an additional charge sheet 29, incorporating the said statement of the PwC therein and a document indicating D91 containing photograph identification memorandum and also one object on the form of DVD indicating material object 13. The defense side petition number 196/20 filed an objection to the same. The learned defense was furnished with the copy under. To this line is very, I would rather say that on 30th, when the adjournment hearing was taking place, there was no mention about this objection, but it has found place here. Then paragraph 174, that 3 months time, the hearing took place, all these things, long leave of time. If lordship allow tomorrow morning for 10 minutes, I can, otherwise, if. Because this 174 and 2-3 more paragraphs, I have to make submission.
Yes, yes.
I can continue.
Tomorrow I cannot, my lord. Tomorrow I am already in the midst of a pardon matter. Because my learned friends, of course, my lord, there is no question, he can take it, I am not on that. He said he will take 1 hour, I thought 1 hour I can finish.
You know, it's all right. We'll hear. There's no difficulty. I mean, the season is so good that we don't mind coming back in the evening. But then we'll close it on Monday. We'll keep it on Monday and close it. You take 10, 15, half an hour, whatever you want.
Monday, only thing is that on 10th I have a match in Guwahati. So Monday in the first half, if lordship takes up.
All right. First off,
First half.
Monday, first off.
Well, I was thinking of day after tomorrow, my lord. Actually, Monday and Tuesday I will not be there, likely, my lord. 10th, my lord, that CB is fixed before the Supreme Court, my lord. 9th
If it
also
is
another,
on
I am
Friday, I
prepared
can-
on Friday, my lord. Friday, huh?
Then you.
Or if it is not inconvenient, it can be on 17th, my lord.
No, we have heard, otherwise what happens is it's,
I follow.
actually the issue is on a very, but then so much has been written and he has also addressed elaborate argument.
On 9th, my lord. Sorry, day after tomorrow.
Then you do one thing. Well, tell Bushra to give this bench only on 6th. No other DB, only this DB.
Day after tomorrow, lordship.
Day after tomorrow. Mr. D. Sekal and senior counsel for the appellate. Arguments have remained inconclusive. Mr. K. N. Chaudhary and senior counsel estate by Mr. S. Bhattakur has appeared on behalf of the respondent. On the request of learned counsel for both the sides, let this matter be listed again on 6/1/2023 for further hearing.
My lord, on Monday, lordship has also fixed that Mizoram medical admission matter. 6th. Friday. That will not take very long. Possible recollect before vacation
Is
that.
that a
matter.
part head matter?
Yes, it assigned to the lordships. Along with Honorable Justice P.J. Saikia.
We'll see whatever happens. What to do, because this is a.
This will not, my learned friend says he will take half an hour, I'll take 1 hour.
Not. Actually, I skipped a lot of things today in the later part.
No, that's all right.
Yes.
These matters, the council must have the satisfaction.
Oh, yes, we are not on that.
And which are very relevant, I am placing actually.
We'll see. Tell them to give this bench. In that Mizoram matter, any breakthrough?
I have not been informed as yet. That will not, that in any case, that will not be a very longish matter. It's a covered. Well, on my learned friend, they said both of them are not available on 6th.
You sort it out. I mean, we have nothing to, you sort it out. Our only concern
My
is
lord,
that
I can agree
once
to
the
9,
matter
my
is
lord.
heard,
My lord, I can agree to 9. First up, there is no difficulty. Only thing is, my lord, a matter may come up on 9. In that case, I'll go. In that case, it can be done this way. My learned friend will conclude. On 17th, I give my report. Or on 10th, I'll go. Okay, 10th, I'll skip, my lord.
Mr. Chaudhary, this is a special DB. This is not the regular DB here.
Let me finish on Friday, Lordship.
Some priority has to. be
Let's see,
given.
my lord. We'll see. We'll work out something.
Friday, we'll see. Let's try. There is no other difficulty. The problem is if we hear and do not write the judgment, then it, because I'm sitting in different DBs, no?
Right.
And judgment writing is,
All right, with the understanding on Friday, my learned friend will conclude. Let us see, my lord. If I'm there, I'll do it.
or we can have a late evening court.
I
also.
don't mind. Friday, I'm done.
Lordship, we are not accused.
Sorry,
We are not accused.
you are not,
We are not accused, Lordship, to stay after 4.
you are not accused.
Used.
Or
Accused.
Okay. Then you must put in a request to the Honorable Chief Justice. Evenings are pleasant now.
Yes,
Then
and become
Lordship will
even
also not stay. After
Sorry?
4, Lordship will also not stay. It is not that I mean me only. I mean the whole community.
Nobody wants to skip the evening nowadays. Huh?
Only
Right.
1 month